Someone make it make sense.
Probably a couple.
Hello, squirrel friends. Oh, let me share my screen, as that's what I thought I already did that. Interesting. Oh, I did already do that. I just have to add it to the stage. Oh, here we go. Cool. Excellent. You know what I have to say about that? Yep, we do. Sure are. So I was looking for this. I wanted to do this before we play this hearing. So I have been reflecting a lot since, the internet came back and everything, and reflecting a lot on this hearing. And, the thing is that there's so many issues, right, with what happened at the end of this trial. You could start with, like, in my opinion, and something that no one else seems to really have noticed, that the fact that, again, they, as I've mentioned before, they never actually finished the jury instructions. She said they were going to finish. She didn't give them time. They just wham bam, thank you, ma'am, right on into closing arguments. They didn't see the verdict form. So there's those issues. Then there's the issues that they didn't see the final jury note. There's that, and then of course that kind of segues naturally into they didn't have time to say something. There's these types of issues which really kind of put, as I've thought about it, I've realized this. I've realized that that leaves room for somebody else to say, well, yeah, but too bad, so sad, because you know what? You could have objected, right, to the defense. And B, it also puts the responsibility, if you will, on Judge Bev that she fucked up. I mean, you can say she did or she didn't, either way. However, if you're arguing to this person sitting here right now with her face, is that really the route you want to go? Even if she deserves it, you know what I mean? So, hi, Io, I'm so happy to see you. And Black Widow, I've missed you. Actually, I've been wondering if you were okay. I was going to actually send you a message. But glad you're here, Io. Glad you're here, Black Widow. So, but yeah, I haven't seen Black Widow in a while here. So I was actually thinking about sending you a message on Discord to see if you were okay. But yeah, is that really the route you want to go if you're arguing to her, right? Because you have to think about that she's very inclined, as we all know, to just shoot this down, right? So there's that. Taking all that, okay, and then adding to that, I've gone through this in my head and like chest gamed this, like to the millionth degree of what is at the heart of the issue, like what is the real thing? Because no matter what I squirrel at it, squirrel. Hi, Maisha. And I squirrel at it, and like it all, no matter what you do, no matter how you slice it, even if you say Judge Bev did something wrong, even if you say she didn't, everybody's going to have this question. And it's, well, if the jurors had a unanimous verdict, why didn't they say something? And to that, I have two things to say. First of all, if you want to know, you're going to have to fucking ask them. Sorry. You're going to have to poll them. You're going to have to poll them, okay? But second of all, it all comes down to the jury instructions. So before we watch this hearing, I want to take a look. This is from a live stream. This is our live stream at the end of June. This is before there was a mistrial, guys. This, I think, was like maybe I remember this was over the weekend, right? So like they gave closing arguments on like, what was it, Wednesday or Thursday, and then this was maybe a Friday. This was before. This was maybe after we only had one note come from the jury. Okay, but this is us looking at the jury instructions and the verdict forms. But I just the reason I have this pull up is because I just have it time stamped, so I knew I could find it. And from where she reads from the jury instructions with the specific wording. And so let's just take a listen here real quick to this.
That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge.
That you should continue deliberating until you have reached a final verdict on each charge. I didn't rewind that to hear the continue deliberating part. They need a verdict on each charge. I mean, that is clear as day. Do you guys want to hear that again? That is clear as day. And there's more. There's more. That's just the first part of this. You should, I mean, that answers the question. That answers the question. So maybe they just told you differently for your trial. So this was me talking to Dr. Bob because he was talking about his experience as a jury foreperson. And, you know, what I was reiterating during this live stream was true, which is the jury only has to go off of what they hear from her. Whatever she says is the rule. So, and we have proof. That's like proof of that, right? The fact that the jury followed her instructions to the T, really, or her. I say her instructions. I guess these are the Massachusetts model jury instructions, which kind of is going to get to my point. But let me find the next part. I think it's right here.
Is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and
the foreperson should check the appropriate boxes as to each charge. Wait, did she say as to or next to each charge? I wish I could go back to the exact spot. Every time I go back, it's like 30 seconds or something. Did she say, what did you guys hear? As to or next to? Yeah, so I think we do go back and we realize she says as to each charge. Let me go forward just a little bit here. Why they don't have that? I'm back it up.
At the end of the day, if you're still deliberating on the questions, you are going to notice two as well as all other.
This warrants a slowdown, y'all. Oh, I slowed down to hear it.
Unanimous member of the jury the court off.
So as to, that's so funny. Check the literally, like that's what she is saying. Okay. We'll see if she says anything differently, but so
this verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to
that's the other part. The part where she says you check the appropriate boxes as to each charge. Or sorry, what was it? What did I decide it was next to each charge? Oh gosh, now I can't even remember what I decided it was. Hold on. Specific instruction that they've heard. We'll see if she says that doesn't date the verdict. So, all right, as to. That was actually as to. That's even worse. The as to each charge is even worse because you should check the appropriate box as to each charge. I mean, if you are a good jury, and you're reading those instructions and you're following them to the letter, there is no way that if you have a verdict on any of 3 counts, but not all 3, there's no way you're filling out these forms based on her. I say her based on the instructions, right? Again, these are them. And this is why, and this brings me to my point. Let me share my other tab. This brings me to my main point here, which is that really the impetus for change here and the way to fix this and to understand it is the real issue that you can, and I think this is the smart way to go about it, is to take it off of Judge Bev and put it on the Massachusetts jury instructions, right? Because that's really what it comes down to. And that's the heart of the question. That's what I was kind of getting to, which is no matter how you slice it, no matter what you think she did it wrong or didn't do wrong or whatever the case is, it all comes down to this whole thing of were they unanimous on any of these charges? And if so, why didn't they say something? That's really the heart of the question. Hi, Lisa Lee, happy to see you. And I think the answer to that is in the jury instructions. And if you can really just focus on the jury instructions, you're taking the responsibility off of Judge Bev. And you're also showing, hey, there's something that can be done about this, right? We can poll the jury, and we can also, I mean, not that it's the time to argue this, but really the jury instructions need to be fixed. So with all of the different issues that the defense has before them, right, and the different issues that we've seen in the motions and in the affidavits and whatnot, I have to say I'm so impressed with Marty Weinberg, and we're going to watch this here in just a sec. I think that he was born for oral argument. It's so hard to hear. We're going to have subtitles on because now we know. It was so, and by the way, for anyone who missed it, so we did watch this live, or we tried to, and about, I don't know, maybe even 20 minutes in, if that, I lost internet due to the tropical depression, Debbie. My neighborhood lost internet because a tree took out a bunch of power lines. And anyway, so I ended up just deleting that because it's just like silly because we were just getting started. But I do know now, we know that we need to have the subtitles on so we can hear him. But he is his approach to this, I think, is really smart. So we're going to talk about it. We're going to break it down. And you guys let me know if you have any questions. I will say, too, just briefly, the reason he's going to be arguing, right, is because Jackson and Eddie technically are witnesses because they took affidavits from these jurors. And so that's why they cannot argue. And that's why they brought him in specifically. But he does a fucking phenomenal job. I'm so impressed. And he does all the things right, I feel like, right? Like he's speaking directly to Judge Bev, but he's also speaking directly to the people. Anyway, let's watch some of this and we'll talk about it. Good to hear the hear yees, guys. Hear yees.
Hear ye, hear ye, hear ye. All parties having anything to do for the Honorable First Justice.
The subtitles got to hear you.
Now sitting in the Norfolk Superior Court within Fuller County, Norfolk, Rodney, if you attend, shall be heard. God save the Commonwealth and this court, and you can see the court now set.
Judge 22117, the Commonwealth versus Karen Reed. So identify yourself, start with the Commonwealth.
Oh, it's the Lallybird. The Lallybird, he's back, guys. Can't get rid of him that easily.
Thank you, Your Honor. May I use the podium? Thank you.
Dude, if ever there was a G, like an OG, like an original gangster, like this dude, definition. Put him in the dictionary. I'm saying that right now.
Judge, there are two central issues.
Don't know if there's a microphone.
There's not one for amplification, but there's one for recording.
If I could actually keep your voice up and turn on the air conditioner.
Oh, are they saying that there's some issue with the microphone? It sounds like.
Sure, I hear it.
At a day like this, I'll keep my voice up.
Okay.
I love him. I love him.
Thank you, Your Honor.
So he starts out by saying there's two central issues, right? So we're gonna keep track.
There were two central issues
Yes,
that
sir.
are raised by the motion to dismiss and the supplemental affidavits that have been filed on the
Also, by the way, I think that this dude is Karen Reed's brother. I don't know. It's just a guess because of his face.
behalf of Ms. Reed. The first of them is whether or not, with their strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court.
So the first of the two, and again, I'm going to just kind of paraphrase some of this because, again, it's so hard to hear him. The first, he's saying there's two central issues. The first is whether or not the jury reached a verdict, is essentially what he's saying, right? That's the core, that's really the core thing, right? What's he going to say for the second?
but it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince Mr. Lally in the district attorney's office that that jury, the jury that Your Honor described as an extraordinary jury, reached a decision.
Right, a couple things. So I have to say, first of all, so you can tell, you can hear he's going off notes, right? So he's kind of, going off of like improvising, if you will. So I love what he just did there. He said, this jury that Your Honor called an extraordinary jury. That's brilliant because it's a compliment to the jurors, but it's also a compliment to Judge Bev. And it's also reminding her that it's using her own words. I don't want to say against her. It's not against her, but it's using her own words in a really powerful way, right? Like, you should trust this jury. You called them extraordinary. So if they come back after them, because part of the trouble, right, is of course, if it's after the fact, the verdict could be, well, who knows, right? Because now that's after the fact. But it's like, remember, Your Honor, you thought they were extraordinary. Let's remember which jury we're talking about here, right? Of course, one thing that's also amazing that I love his strategy, it's not, he doesn't come from a place of opposition. This is brilliant. If you're up against Judge Bev and you're up against this Commonwealth in this situation with this case, in this court, this strategy of we're all together here, guys, is brilliant, because it would be so easy to come in and think about it, right? Like, had it been Jackson or Unetti, had they been able to be the one arguing this, it would probably be quite a different tone. I think it worked out so well that they needed to bring somebody else in due to these juror affidavits and Jackson and Unetti being technically witnesses. I think it worked out. It was a blessing because this was so smart. They brought in a third party who has not been involved, right? Who doesn't have this certain rapport, if you will, right? With arguing in front of Judge Bev. It's a brand new face. It's someone who clearly is incredibly well respected and has all this experience. It's just, and it's like, he's just even keeled, man. This was so smart. So this whole approach, that's the other thing I was going to say, this whole approach of we're all together here. We're all on the same page. We're going to talk more about that as we go on, but I think that's also another brilliant strategy. But the other thing I was going to point out is that he's saying he's laying, this is his introduction. He's laying the groundwork. He's setting the expectations for what he's going to be talking about, right? So he's saying, I'm going to discuss that the framework already exists. There's already a pathway here. You don't have to do anything brand new. There's already a pathway for you to use these affidavits, okay, as evidence that there's a verdict. Now, why does that matter? Because there's different approaches one could take here, right? His initial approach, like his goal here, from what he's arguing, is you should be able to take these affidavits and use them as evidence of the verdict. Why is he going that route? Well, because I think that he feels like that would be, that would be the best thing for the defense, right? But I think he feels like there's a better chance. I think he feels like it's going to be tougher to try to convince Judge Bev that it's okay to pull the jury. Now, I think that's the way to go. I think that's what needs to happen. But he's going to use that as a backup, which is really smart. He's saying the obvious choice is going to be, as you're going to see, Your Honor, I'm going to lay out the framework. The obvious choice is going to be that you can use these affidavits from this extraordinary jury in your own words, and you can trust what they're saying, and you can take it and you can use it as evidence, you can use it as proof, and I'm going to show you how you can do that. That's going to be his first number one thing. And then the backup, right, is going to be polling the jury. And all of that is so much more, this is a much smarter thing than going straight to a motion to dismissing the charges, right? This had they come in and just right off the bat and just been like, yep, we're trying to get you to dismiss the charges, whatever. Again, it's just not, this is really smart. This is the smart way to do it. And it's also putting, again, it's taking the responsibility. It's not saying anybody did anything wrong, right? But it's really just, and it's just getting to the heart of the issue, right? Because it really was those jury instructions, like we saw. So, all right.
It will be consistent with their jury service and consistent with respecting that jury service that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2, and lesser includes the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history.
Remember, he said that at the very beginning, he said there's going to be 2 main issues. He's getting to the second issue now.
And it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have
My guess is
evidence
manifest.
that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial. Evidence not known to.
This is brilliant. It's like the oldest trick in the book, right? If you will. Flattery. If you know, this evidence wasn't known to Your Honor. I mean, he's doing this. I have such mad respect for him, man, because he's able to really just come in here and do everything right in terms of what the best, and you're talking about a judge who's impossible, man, right? Like, this is an impossible task, what they're doing. And you've got a judge who's been difficult all the way. And instead of coming in again from a place of opposition, you're coming in from a place of we're all together on this. You know, you didn't do anything wrong. You did everything right. I mean, I just applaud him for this. I think this is so good.
Mr. Lally and the prosecution or the defense.
Same here.
That
Yeah.
in fact, the
No
note
one did
they
anything
wrote to
wrong.
Your Honor after the
No one
two
did-
charge
no one
on
did-
July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts and therefore would lead ineluctably to a mistrial declaration. Or 2, that the impasse was on 1 count with multiple lesser included charges, but did not encompass counts 1 and 3.
Right here, he's just pointing out why in the Commonwealth's opposition filing, that their case law was not on point, which is what I have been saying from the get-go, because it wasn't on point.
Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court. Neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such an historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th?
9th.
If I'm absolutely correct. 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel.
We can't just accept a fiction that the jurors were at an impasse on all 3 counts. And it's just, again, you go back to those jury instructions directly from Judge Bev's mouth, right? And it's like, obvious. It's obvious. It makes me feel like this might be happening more than anybody realized in Massachusetts, right? If they've got multiple indictments and there's something where there's also included, it makes me wonder how many people has this happened to using these same instructions.
They were not, and a 5th juror is saying,
but just people never find out.
They were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision making. The second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that.
So here's the thing about
what we know is that 4 jurors reached out to defense counsel.
The manifest necessity. So that's the second thing they're going to go with, is that manifest necessity, which we anticipated. The thing is that, and I know you don't ever want to have just the one argument, right? But the reason why I think, again, the jury instructions is the much more powerful way to go with, like, the jury, okay, when I say jury instructions, I mean their verdict, right? What were they hung on? And really, for me, it comes down to the jury instructions, which is why I'm calling it that. But the other thing is that the other reason I think that's smart is because I don't think you want to go with, again, even though while I completely, I timed it, for anyone who didn't see that video, I timed it. How much time did the defense really have to object to the mistrial? And it was 4.65 seconds. The thing is that even though there were so many issues again with that whole thing, is that really the route you want to go when it leaves room for argument? It leaves the room for somebody to say, well, the defense didn't object, or the defense seemed pleased with the mistrial when it was over, or the defense didn't have a problem with the Tui Rodriguez instruction, all that, right? That's why, again, if you go this route of manifest necessity, you're opening the door for all of that. You're opening the door for more argument, in my opinion, where there is argument, right, that could be made. But when you look at just the verdict of the jury and you look at the jury instructions, there's only one answer if you want actual justice, in my opinion.
Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't denounce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory.
Right.
And that makes them more trustworthy.
Yep.
They corroborate each other. And I contend
to corroborate each other.
Voicemail left on Mr. Lally's phone, which he responsibly shared.
And this is where he's going back to this idea of, You shouldn't need any more. This should be enough. You can trust what you've got with these affidavits you already have, that this is enough to represent all 12 because they don't contradict each other. And because and as he's going to get to, that if there was anyone on this jury who thought it wasn't true, they would have spoken up by now. That's what he's going to be getting to here.
The court essentially saying this was probably one of the 4 jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity.
So this is a really good way. What he just did there is he pointed out that there was a way to have the jurors communicate and keep their anonymity, but he did it in a way that didn't blame Lally, or not to blame Lally, but he did it in a way, even though it would be so easy to be like, what is Lally saying? What Lally's saying is bullshit, right? Like, obviously it can be done. Like, no one's saying they have to not be on. He's doing this in all the right ways, right? He, instead of like pointing out what Lally did wrong, he's just pointing out how the defense agrees that it's important to keep the anonymity of the jurors, and that they were able to do that. And then it's like, just follows logically, well, that means that anybody could do, like the Commonwealth could have done that as well and chose not to. He doesn't have to say it, right? It's implied. But by not saying it, he's just taking this route of, what is it? You catch more flies with honey type of thing.
But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors do. Not one of them, to our
Fee and Circle is accurate.
has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions.
There's a couple other cases that I just heard about that are out of Boston or Boston area. What was the one recently I heard about? Some like multi-millionaire dude who had some connections to Harvard and he murdered his wife and daughter. I tell you what, every time now that I hear though about something happening in Massachusetts, like a trial, it's always gonna raise, alarm bells for me of like, well, I hope, God forbid it's anything like this,
I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks.
Right.
Nobody disputes, in other words, none of the 7
No one
or 8
disputes,
jurors
yeah.
that are not, represented by the series of affidavits of
This is
defense
brilliant.
counsel dispute.
His argument, this is exceptional. This argument is, he's saying that, wait, hold on, let me back up a second. I had a really good way to say this one.
Represented by the series of affidavits.
Right, okay, I know how I was going to say. So he's saying the jurors that are not represented, 7 or 8 jurors that are not represented. This is brilliant. What he's saying is the fact that they're not represented means they're represented, essentially. They're not represented because they didn't come out and dispute it. Therefore, they're represented by their other jurors that did come out and say it was unanimous. It's brilliant.
affidavits of defense counsel.
I love it. I love it. That's good law right there.
Representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I try to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance.
That's important.
They are making
Form is not to be exalted over substance. What a powerful sentence right there, because that's really what this comes down to. You know, because the form is the issue, right? Like form here has two meanings. There's like form as in the concept of a form, like something being done a certain way, but also the jury forms, right? Like the verdict slips, those are forms that weren't filled out. And part of the question is, well, why didn't they put a verdict down on counts 1 and 3 on the verdict slips? Well, we've covered that again. She made it real clear that they're not to check those boxes unless they can check all the boxes on each count. But again, that's why I think this is so brilliant, because the form over, he says, we don't want to put form over substance. The substance here is what the jury's verdict was versus what they filled out. And again, you know, it's clear to me they were following her instructions. Yeah. So
in that point, I mean, I've done this for 52 years.
amazing.
Procedures important. Form sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having
I really like his
affirmative
demeanor too.
obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, where there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts,
Right.
is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call the central proposition, which is, where's the default? Is the default from not asking the jury about these other counts?
Right.
Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity
Okay.
in the first place?
He just came full circle back to his two central arguments, right? He said is the default that the jury, well, the first, I don't want to misquote him. The first thing was the verdict. Hold on, let me just make sure I don't want to
default instead that the prosecution not asking the jury about these other counts.
Right. Now, what's interesting about that is that could mean, I don't know if he means that's interesting. It could be like that on purpose. That sounds like that could be referencing having not asked at the time, or it could also mean not asking now. Let me back that up because I think that's interesting.
Central proposition, which is, where's the default?
Where's the default?
Default from not asking the jury about these other counts.
Is the default from not asking the jury about these other counts? And again, it's interesting because it's like he could be meaning at the time, he could be meaning now, and he could also be both, right? I think that's pretty clever, though.
Ms. Reed goes to trial again, or is the default Instead, that the prosecution simply cannot again re-prosecute her when there was not manifest necessity.
And again, so here he's just pointing out that manifest necessity, the burden falls on the prosecution to prove the manifest necessity.
In the first place, for the counts 1 and 3. The Supreme Court 67 years ago, I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice.
Crazy there's not more people there.
Talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Map v. Ohio extended suppression remedies for Fourth Amendment violations.
Oh, look at you, Maddie.
These
Here.
were all unknown until the war.
Oh, there's the jury box right there. We can see the chairs. They had nice chairs, didn't they?
The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment.
Wow.
With whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these 2 jurors where we have a principal basis to question their impartiality. The SJC just 3 years ago.
So that was what he's saying there. His point there is this was 11 years ago, the Boston Marathon bombing. Wow, I remember that. It feels like that was just yesterday almost. But he's saying that they're in 100 pages, in this lengthy opinion, they're saying bring back these 2 jurors, even though this was 11 years ago. So that is actually a great example, right? Because with this whole idea of like, oh, well, it's, it's a couple months. No, I mean, not even, right? It's like 2 months or whatever after. Yeah, not even. It was what, July 1st? Yeah, so not even 2 months. Anyway, it's like, yeah, that's 11 years and they're talking about bringing back some jurors. So I think that's smart.
Dealing with a lawyer's allegation that there had been a racial statement, it's called the McCallum case, 485 Mass 790, said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdaugh case from South Carolina.
There it is.
Who was accused of his family.
The way that I died when I lost my internet and we were trying to figure out what to do, and I didn't know yet. I hadn't gone outside and seen the tree and all that yet, and I didn't know what was going on. And Fender was in the Discord saying, and they just mentioned Alex Murdaugh. I was like, you've got to be kidding me. I can't even, here's like all the worlds colliding, right? Like insane that they mentioned this. I mean, it's not insane, but it's insane. Yeah.
There was evidence recently, according to
Courthouse
the
Becky,
that a clerk spoke to a juror. And
my
the
God.
judge convened a hearing, questioned the people who were connected to it in order to make a decision.
I mean, it's
in other words, regularly, judges who receive reliable evidence that there was extrinsic evidence that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during, did the jurors access the internet when they were when they were judicially prohibited from doing so, courts reconvene hearings.
Mhm.
And I can test that it can be done anonymously, doesn't have to
course they
interlock into the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't an acquittal entitled to just the same kind of deference? You know,
Yeah.
we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision.
Yeah.
We're not asking to have any.
So he's saying this is even a bigger deal. I think this is a great argument. What he's saying is, in these other cases where we have examples of people bringing the jury back in, right? Murdaugh and other trials, were brought back in because there was maybe this concern that there was some sort of outside influence. He says here, this is even a bigger deal, because the concern is that they reached a verdict. This is the point, right? Is to not retry somebody for the same thing twice. And so I think this is a really important distinction that he's making, that he's saying this is, if juries can be brought in to be asked these questions in these other cases, it's for much lesser things even than the fact that a verdict was reached, right?
Inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them.
Mm-hmm. Great point.
Did you reach a verdict?
This is another really smart move. Why? In a way, it's kind of like, again, kind of like pointing out, well, you could have done it at the time. It's not telling her she did something wrong, but it's kind of, in a way, showing that this could have been prevented. And I mean, in the most subtle of ways, he's saying, all we want to do is do exactly what could have been done at the time. See, that's exactly why I'm saying that, right? This is no different than what could have been done at the time, just by polling the jury. And it's like, well, man, isn't that a shame that wasn't done, right? But oh well. But yeah, just another really brilliant point there. And what else was I going to say? Oh yeah, I know what I was going to say. So like with Murdaugh, for example, when there was this discussion and when all this House Becky shenanigans first came to light, and there was talk about this after discovered evidence and, polling the jury, it was the same thing. The whole contention was, how are we going to, if you follow that at all, everybody's talking about how are we going to be able to do this without inquiring into the deliberations. That was the whole topic of the debate for a long time, right? That was the whole thing. So that really has good recent, precedent in terms of, you can go and look and see, like, that was the whole thing. That was the only reason why anyone would have said, oh, we shouldn't have an evidentiary hearing. The only thing to say that would be like not in favor of it was to say, well, we're worried about the jury deliberations, right? And infringing upon that. But it was clear, 100% clear, that doesn't need to be infringed upon. You can totally ask these questions. It's no problem at all. It's settled, right? And so, anyway, I was going to point that out. But I think I love the way he says this here about, all we're asking, Your Honor, is for you to just ask what you could have asked at the time. Beautiful.
What was that verdict? What about count 2? No. What about count 3? Yes.
Yep.
So there is precedent, although slightly different, but we contend no less important.
I mean,
to Your Honor,
he's being so polite. I still would be like, Your Honor, why didn't you fucking do it at the time? You know what I mean? Like, I still am pissed about this, right? Like, she didn't follow Rule 27B. She didn't follow the shit she's supposed to be doing. Like, And we broke that down, and we looked, and then we were all confused as to why she wasn't doing what she was supposed to be doing at the time of the mistrial. We're like, wait, she didn't do this and that. Anyway, she could have pulled the jury, but whatever. Nonetheless, he's much less, he's much more even keeled than I am about it, obviously.
Making
He's not worried about
a
it.
decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers,
Okay.
of the
Attorney's
jurors.
declaration.
Sorry, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors.
Right.
Ask them whether they would read the lawyer's affidavits and affirm that they're accurate.
So that's a really good point. That's like a medium step, right? So again, going along with this idea that these 4 or 5 jurors, however many, represents the whole, because the absence of anybody coming out and saying that otherwise, right? That's what he's saying, right? Again, the 7 or 8 that haven't come forward, by them not coming forward to say that something was incorrect, he's saying it affirms what the 4 or 5 have said. So again, relying on those 4 or 5, saying they represent the whole, they represent the group, they corroborate each other. This is a good medium step, which is if the affidavits coming from the attorneys isn't quite enough, that's fine. There's this medium step. Again, if you don't feel comfortable polling the entire jury, we can just reach back out to those 4 or 5 jurors that, again, in the way he's describing it, they represent the group, and we can have them affirm the statements. That's a great medium suggestion,
Or alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit.
Mm-hmm.
It could be 2 sentences.
Yeah.
We reached a final decision unanimously.
And I think giving Judge Bev these different options is really smart. I don't know that she's going to go for any of it. At this point, I don't have much faith in her or the justice system in Massachusetts, unfortunately. Even though logically, I feel like you would have to be crazy to not poll the jurors at least take one of his suggestions, right? That was going to be my point, is the fact that he's giving her multiple suggestions, multiple options, I think is so smart. And that, again, to me, it's like you'd have to be crazy not to do them. It's like, it just wouldn't, I just don't have much hope for Judge Bev, sadly. I would love to be wrong. I would love to be like, wow, I was wrong. She did the right thing. Like, Judge Bev, Lally, y'all, if you guys are never going to watch this live stream, but just in case, please surprise everybody and do the right thing. Seriously, like, this is your opportunity. Everyone's going to think that you're going to do the wrong thing. Why don't you guys? And the reason I brought Lally into it is because, you know what? Again, the Commonwealth could choose to just not bring those charges. And so there's an impetus that falls on them as well. Regardless of what Judge Bev does, let's say she just shuts all this down and says, no. The Commonwealth could still do the right thing. So one of them needs to, surprise everybody in a good way, not a bad way for once, I think.
To acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line.
That's
What
good,
is
yeah.
the truth here?
What is the truth?
Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure if legally you would, but to keep this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We have
And again,
responsible court officers.
And they could even reference Murdaugh again here if they wanted to, with how they did it, right? Because they still had cameras. It was still public. That evidentiary hearing was still public. They just didn't show the jurors. It was brilliant. You got to hear the jurors, but you didn't get to see the jurors. And they used letter numbers. And it's funny, I didn't even make that connection until now. I never even thought of that. I don't know that I've even heard anyone say that. So the fact that the defense has been calling the jurors A through E, they've been using letter numbers. That is so funny because I wonder if they were already thinking about Murdaugh right off the bat with that, because remember, that's what they did in Murdaugh. They gave them alphabet letters, and it was so funny because they seemed to be kind of like not in order, right? Because like there was a juror Z anyway. But yeah, they could even just use Murdaugh as an example for how you could even have the evidentiary hearing and keep it public.
There can be 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence that was not, to establish a procedure consistent with McCullough, consistent with Tsarnaev, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence.
Me neither, Lisa.
From improper contact with a third party.
I mean, it's hard to believe, right? It's hard to believe that they didn't have cameras in that neighborhood. It's really hard to believe. I agree with you. They're all cops, and it's all those big houses, and they're right outside of Boston. It's hard to believe.
And help us investigate this.
Help us investigate this.
I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Luford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial.
Yes.
They were convinced by these jurors.
This is so important. This is like what I was saying about doing the right thing. Because again, even if Judge Bev denies what they're saying and doesn't want to have anything to do with it, the Commonwealth can make the right choice. The DA's office can make the right choice. They can still do the right thing. And I think this is so important, again, because it's coming from this perspective of like, we're all on the same team. We're all together here on the side of justice. I think that is so, it would have been so easy to want to come in and be combative. Lord knows I would have wanted to do that and come out, yelling at everybody, right? Or whatever. There's so much to be mad about. This, I just have such respect for him, right? Because he's coming at it from this place of we're all on the same team, we're all on the side of justice. And it's like, almost hard to even believe those words, right? Because it's like you see what the Commonwealth has been doing and everything, and it's like, are they really on the side of justice? But he is still compelling them to do the right thing, which is why I have so much respect for him, right? He's not given up faith. He's not given up hope yet. He's not given up hope yet that they can do the right thing. And the other reason I think this is really important is because everyone is hearing this, right? So the public is now, for anyone who wasn't already aware in the public of the fact that the Commonwealth could choose not to bring those charges again, because not everybody's going to know. Not everybody's going to be watching LawTube and stuff. Some people, they might just see some of these things or whatever, or some part of the hearing. Anyway, he is letting everybody know by saying this, that whatever happens after Judge Bev's decision, regardless of what it is, the DA's office has options here, right? And that's important because these are elected officials, elected positions, the DA. So it's sort of like, I think it's really smart. Like, I remember when I heard this the first time as I was walking around my neighborhood and trying to, find if the internet people were coming, and that was such a crazy day. But I remember hearing this and thinking, oh my God, that is so smart, because that's putting the power, right? Again, Morrissey being an elected position, that's giving power to the people, right? In my mind, like as he's saying this, I'm like, he's talking to the people who elected that DA, because what he's saying is that the DA's office has options here to do the right thing. So that even, in other words, even if Judge Beck denies it, right? And then let's say the Commonwealth still wants to retry again on those charges. Now there's the backup to the backup to the backup plan, which is the public, right? Using the public as your plan Z or whatever of your last resort, because the public, right, could be so upset about it, and people will listen sometimes, right? They have to, again, because it's an elected position, DA's office. I think that's really smart. It's reminding him that he represents the people, he serves the people, and it's reminding the people that they can vote him out of office, right?
Under oath.
Yeah.
What they've not yet been convinced by, which is defense counsel, this was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. You know, this to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected.
Oh.
I want the prosecutor to get the facts in the best way we can at this point in the case, which is through your honor.
Again,
order a hearing.
I think this is great. Because imagine if you're someone in the public who lives in the area who hasn't been following everything going on in this case. You know, you don't know everything about Carrie. Maybe you didn't watch the whole trial, but you hear something about this part, right? Or you just see this hearing. This is so crucial because he's laying it out very clearly. If nothing comes of this, and if the Commonwealth still brings these charges, right, what he's saying is, shouldn't the government want facts? Shouldn't the government want the truth? You know, I mean, it's powerful stuff. And it's like, you should, I mean, he's not saying this, I'm saying this. People should be afraid if the government does not want the truth. I mean, really, right? Because what are we even doing? Right? We don't want to live in a place, I don't want to live in a place where the government is like, no, I don't want the facts, I don't want the truth. Like, sorry, what? So, again, he's laying this groundwork for people to understand what's at stake here, even if they didn't follow his trial. You know, again, people that know nothing about Karen Reed could hear something like this and start to be like, wait a second, hold on, what? And it could get their attention, right?
Don't make Miss Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her.
Again, think about I'm just thinking about this case as a great example too, right? Where the people speaking up has been such a big deal. And in Canton, like we've seen it from watching the select board meetings, right? We're watching people do what, you know, it's crazy, right? It's like almost like going back in time where it's like people having to really fight for justice and having to really speak up. But what we're seeing is it makes a difference. And they're really being stubborn in Canton, right? They're being really stubborn. And you know, people are really up against it, especially the ones that come out time and time again to these select board meetings. I guess now they're on Zoom, but you know, they've been doing this for years and they haven't given up. And so again, I just love this approach because it's empowering the people that if all else fails, you guys can still have a voice and you should speak up, you know, against tyranny, you know, in a way, right? Against this nonsense if they don't do the right thing.
Once and failed
right, being corrupt. Yeah.
They've not given a single case where facts like this have been ignored. Not a single precedent.
Saying their law is not
nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip. Nobody knows when it was written. We have Bluford. It was clear.
I was just talking about you. Were your ears ringing? Where have you been, man? Are you okay? it's so funny because I was just thinking, man, I haven't seen Kids Mitts and Black Widow in a hot minute. And I actually said that at the beginning of the stream, Black Widow popped up. And so I'm like, I wonder if that's what's happening. But I'm so happy you're here, man. We've missed you.
Further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be
again. This is such a smart way to kind of wrap this up. I hope Mr. Lally will join me. Again, it's compelling him to do the right thing. I still believe he can do the right thing, he's saying. He says, I still have faith that Mr. Lally can do the right thing. But it's such a subtle way. It's such a subtle way to show if he doesn't join him, he's not doing the right thing, right? Again, it's to show the people, like, this is your government, people, right? This is who's supposed to be representing the people. Because it's like, I invite you to join me and do the right thing. But I just love that because the reverse is also true. So I understand, Kit Smits. Totally understand. Have you been writing stuff or doing piano, practicing piano?
So let me switch from the
Now he's gonna move over to piano.
its implications to manifest necessity. In this case, we have explicit guidelines, which have been set out by the Supreme Judicial
I'm not even going to say it.
that look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly, and whether the mistrial order was avoidable.
That's a good question, Lisa Lee, and I don't know if that's public, like in terms of case by case when it comes to like taxpayer dollars, but a lot.
There were any viable options, whether the court essentially had no choice, no options. If here at minimum, with 4 or 5 jurors saying, we believed her to be innocent, or we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial.
Right.
The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational explanation for the note, a logical one, which is we were addressing only charges.
Yeah. I think I wouldn't bet, or headphones or something. She really just seems like she's just not even, she's like out to lunch, as they say.
Count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, was one of the central decisions that started formulating the jurisprudence around double jeopardy.
Commonwealth
manifest
Stewart.
necessity.
Yeah, true.
It says prosecutor must shoulder the burden of justifying the mistrial.
So again, now he's getting to who has the burden when it comes to the manifest necessity, and the burden falls on the prosecutor.
His burden is a heavy one, citing to Arizona v. Washington.
I just have to say real quick while Kit Smith is here, because even though it's in the middle of this, but I meant to say at the beginning of the episode, but I'm glad I'm thinking of it now. So the episode that I've been working on for the next Ezra episode, Wisconsin v. McCandless, dude, I almost fell over. I don't even have words. The overlap, oh my God. It's like I had to actually pause the testimony that I was watching and editing in the next video. I'd actually pause it because I was like, my brain's gonna blow up. I couldn't even. I still can't believe it. I'm like, you've got to be kidding me. Like the overlap with Murdaugh. And it's specific to that moment that I remember you were here, Kit Smith, when we were talking about this, just follow the railroad, right? That live stream still has the title of my longest live stream ever. I'm pretty sure still has that. But anyway, but where he has the car parked, that's that moment, right? Where he has the car parked on those railroad tracks and he pauses and no one can really figure out why, but he's doing something with Maggie's phone, right? And it's like, what is going on here? And it's like nothing, that doesn't make sense. It's like a weird place to have the car, and it's a weird moment to be parked, like all of it. And the way he's like perpendicular to the railroad. Anyway, I just was getting to this point in this testimony editing this next Ezra episode video when we still don't know yet what happened to Alex's phone, and we're still getting to that. And I was just like, oh my God, I don't even have the words. And this is before Murdaugh, but it's like the similarities, it's just gives you goosebumps. That's all I can say. Oh yeah, of course I did. Oh yeah, we've already heard that part, but yes, of course. As I said, like, you know, my internet went out because of the tropical depression, like 20 minutes into the hearing. But Fender, like, we were all here for the hearing, right? And then like 20 minutes in, like, I lost my neighborhood, you know, we all lost internet. And like I set out on foot to go see what was going on, but everyone was keeping me up to speed in the Discord and letting me know what was happening. And then Fender was like, and Murdaugh just entered the chat. And I was like, you've got to be fucking kidding me. I'm losing my mind right now. Of all the things, and I'm not here to cover this live, you know. Yeah, that's funny. Thank you. I that means a lot to me, even that. That means a lot to me. Because you guys know that's got cases like my baby. But yeah, so but this next Ezra episode is it's gonna be really good. I have to try to think of how I can come up with a good name for it that has the overlap with Murdaugh, but it has to be able to fit in the Squanglin's speech bubble. So,
the Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nickel decision because it's the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, a everybody discovered that there's in fact a rule of criminal procedure and that defendants could waive a jury of 6 just like they could waive a jury of 12.
You know, I'm also thinking about, I was thinking about Spencer. Shout out Spencer. I'll put his command in the Discord. That, like, you know, I know that he has had a hard time because he's just, I think he doesn't have much trial experience, and he jumped right on in with Duffy Heard and then Ezra, and he happens to have unfortunately had issues with in the past with maybe abusive girlfriend or something along those lines. And it's like, and I was like, dude, those are the only 2 things that I've ever covered that have anything to do with that. I'm like, look at Murdaugh, look at Carrie, look at all the other trials. Like, they have nothing to do with, like, you know, spousal abuse or intimate partner violence or anything, right? Like these and I'm like, man, like, I was just thinking about how this would be, like, he could jump in here, right? This is incredibly interesting. This hearing is so interesting. And this wouldn't be, you know, I don't think would be, you know, difficult for him at all. Anyway, Spencer, if you're listening, this is a good one for you. Hannah Payne, don't know who that is.
As I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant?
Oh, yeah, right.
A second time in the face of double jeopardy's manifest necessity requirement? Or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B.
Thank God.
See, everybody,
Guys, I have to hallelujah, right? Hallelujah. Because the amount of time that we spent talking about Rule 27B, shout out to Dr. Bob, prior to long before, I mean, even before closing arguments, we were talking about this rule. And we were studying it. We spent a lot of time. And then Judge Bev didn't follow what the rule said to do, and we were all confused. And then even in the wake of all this, I kept saying, why is this not coming up more? And so whenever I've covered these documents, some of them were live, some of them weren't live. You know, Rule 27B was referenced, but I was like, why are they not using it more? But I was happy whenever it was used, but it was like, Anyway, thank you, Marty. Marty, I think, saved his best, like my overall take is that he saved his best lawyering for the oral argument versus the written motions, which that makes sense. I think that's kind of like maybe an old school thing, because I think that his oral argument to me is much stronger than the written motions. Anyway, I'm just thank God. That's all.
focused on Roth and Bluford.
That rings a bell. Is that a case that's going on now, or did that already happen?
Where
Sounds
all of
vaguely
them were single counts with lesser included. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we have 3 counts, not 1. And
Yep.
Rule 27B,
Thank
we
you.
were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her. Says as follows:
Lisa?
the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the
Here.
judge may first require the jury to
Here.
return verdicts
I mean,
those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit.
the advisory note. I mean, this is exactly what we read. Dude, Dr. Bob, I know he was on vacation when this was happening, and he must have been so happy. I'm so happy. This is the thing that we've been waiting for. This is the moment we've been waiting for. I mean, like, I'll have to go back and find exactly when was the first day this came up, but we read this and we just, dude, I just thank God finally. That's all I can say.
This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on.
Yep. And it uses the word must.
That rule had it been
Court must.
brought to the court's view, provided a viable option to a declaration
I mean,
of a mistrial.
here's something I have to say. I mean, that's a rule, and Judge Bev didn't follow it, and we pointed that out at the time. And so, but what's the point of the rule if nothing happens, right? You know, there's rules that have to do with different things. We have to follow rules. The public has to follow rules, right? Right. If we don't follow the rules, we get arrested, right? The point. That's the point. The point of the rule is if you don't follow the rule, there's a consequence. So what I don't understand is when you've got these rules that apply to the judge, like in this case, the court must. The court is the judge. The court must. Not may, must is what it says in that advisory note in Rule 27B. But then the court didn't, and then nothing happens. So I don't quite understand what the point is then, you know?
It would have justified the courts, it would have required the court.
I mean, again,
It was justified
we can't just not follow rules. I say we as in the people, right?
to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, it provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them two principles guiding our review.
I mean,
manifest necessity.
and I'm just arguing with myself in my head over this, right? Like I'm thinking to myself, well, you know, they could say, oh, well, it's up to the defense to object and say that something didn't. But then what's the point of the rule, though, right? Again, I'm just arguing with myself over it, like because there's no way around it in my mind. It's a rule, right? The rule is there for a reason, and the judge is supposed to follow it, right? I mean, everybody is supposed to follow the rules. That's the whole point. That's what society is.
One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard. And I'll address that sentence.
Yeah.
And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives. And
Like to me, when it comes to this stuff with the manifest necessity, I don't think that the biggest issue here in terms of the court, you know, I don't think the biggest issue is that she didn't give careful consideration to alternatives. I don't think that's the biggest issue. I think the biggest issue is the first part of Rule 27B, like we were just saying, where she did not poll the jury. That's the problem. Like she didn't follow the rule, you know? Right. Well, yeah, I guess that's kind of what I was just saying is that like, but what's the point of the rule though? If like, that's what I was saying. Like if the impetus is on the defense to object or just then what's the point of the rule? Right. I mean, I guess, I mean, yeah, obviously you can use the rule later on, like they're doing here to cite why something was wrong. But I mean, it doesn't make sense. It doesn't even make sense just from a philosophical standpoint that there's rules that they have to follow, but they don't have to follow it. And, you know, it's like only if somebody says something, does that mean that they broke through? Like, okay, it's backwards logic. It's messed up logic. It's like saying, okay, you know what it is? You know what it is? It's that idea. Okay, you can compare it to this, that only if you get caught did you do something wrong, right? Like if somebody steals a car, but no one sees them steal a car, did they steal a car? It's like that. No one would think that, right? That doesn't make any sense. It's like that type of logic. So that if the judge breaks the rule, but nobody says anything, the judge didn't break the rule. That's not how it should be working. You know what I mean? Yes, Lisa. Yes. 100%. All she had to do was poll the jury. Yep.
respectfully, for a variety of reasons, that neither of those two guiding principles were met by the evidence that would occur on July 1, where we have the chronology of Your Honor taking argument from counsel regarding the warning note, and the prosecutor didn't want a TUI instruction. Defense counsel did. Your Honor elected to give a TUI instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs.
Mhm.
And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor.
Yeah, there you go. That's your argument right there.
The court's attention.
Rule 27B. I mean, really.
You
Ugh.
know, again, usually this would be an issue where the defense counsel could be criticized when they don't
Here.
object to instructions after.
Right here. Okay. Obviously, this is an issue where what he's saying. Obviously, this is an issue where the defense counsel could be criticized when they don't object to the instructions. Let's see what he says.
Trial instructions, the Court of Appeals makes it very hard for appellate lawyers to succeed in reversing the judge's not providing an instruction that later they learn. If this is double jeopardy, this is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart.
So what he's saying, he's making a distinction that because the issue here is double jeopardy, it's not on the defense because that's burden shifting, right? He's going back to his point that the burden here is on the prosecution because it's double jeopardy. So he's saying that while people could be critical of the defense because they didn't object, he's saying it's not their job because it's double jeopardy. The burden is on the prosecution.
Recall the appeals court in a case, Commonwealth versus Oregon, we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying the mistrial rests on the prosecutor.
Yep.
And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in the court did.
Well, how generous of him. Is he kind of trying to say, well, maybe you didn't know about Rule 27B, maybe that you may not know about every rule in every book. It's like, that's so generous. Like, she should know, in my opinion. Like, she should know the rules. She should know the rules. But this is such a better approach. I'm glad I wasn't me arguing in front of her. So Lisa, yes, he is talking directly to Judge Bev. That is who he has to convince. And Kit Smits is saying we're assuming that there's not a conspiracy. I think what Kit Smits means by that is that Judge Bev doesn't have other people that are maybe like helping her make decisions. Maybe is that what you mean, Kit Smits? But yes, I mean, under any normal circumstance, and assuming that yes, she makes this decision alone is how that's supposed to work. This is just up to her entirely. And then, of course, like we've said, if she doesn't, whatever her decision is or isn't, the Commonwealth can always not bring charges. So there's that.
It's on the Commonwealth to have advised you, Judge. So this was a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria of a full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors got strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And
the other thing I should say is, for anyone who didn't see the video where I broke down that document I guess it was the latest court filing prior to the hearing. But when I was breaking down that document and I was talking about the significance of this count 2 and that the jury, what it means specifically that the jury was deadlocked on that count. And the only way, there's no way around it, that some people thought that she must have hit him with the car, right? Because they clarify in the latest court filings that, nobody thought she hit him on purpose or that she knew she hit him. And I was thinking that they were going to say, or that she hit him at all. But what the juror clarified and said was that they didn't think she hit him on purpose or even knew she hit him. But what they didn't say was they didn't think that she hit him at all. And so I thought that is so interesting because, and I'm just bringing this up because he's talking about how it's clear that they were deadlocked on count 2. And I just think that's so interesting because I was thinking about it in that video about how, I wonder if what it came down to was the taillight pieces, because the only other explanation for the taillight pieces getting there, if he wasn't hit by her car, is that it was planted by law enforcement. And I wonder if that was the real reason why people were really deadlocked. Like, because if you look at all the other evidence, right, the medical examiner and the ARCA dudes, and now if you look at all the evidence, he wasn't hit by a car. But yeah, I wonder if the taillight pieces is really what was the crux of the whole thing, to where people couldn't go. Like, it's like, again, like this is what I said in the video, but it's like choosing between two implausible situations, right? That law enforcement would plant evidence and that he was hit by her car. But between the two, if you have to pick one, right? And I wonder if that's sort of what was the problem. So,
in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, the centrality of double jeopardy. Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure.
Yes, I love it. It's an invitation.
Allows the
Right
defense
thing.
lawyers
Love
to
it.
supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. And Ms. Reed was acquitted. Bring the jurors in, Judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
You want me to hear?
Where are you?
All right, time for the Lallybird. I'm going to speed him up because, sanity.
Your Honor, the Commonwealth would ask, request that the defendant's motion to dismiss be denied.
Oh, the sound is even worse.
Really had an opportunity to be heard and object to the declaration of Mr. Roberts' case, and then Mr.
a
Roberts
bit
prepared
too fast.
To that last point, as it applies to what counsel was referencing in regard to Rule 27D, what I would submit there is there's a stark difference between what Rule 27D encompasses and what counsel was asking for the court to do. And what I would say is there's a difference between what Rule 27D talks about, which is taking, or the right of the court to take partial verdicts, which certainly the court is entitled to do, if that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has.
This is just such flawed, this is like circular reasoning again, right? Because he's saying, well, there was no indication that there was a partial vote or partial verdict. So then why would you ask? Well, you're not going to know if you don't. I mean, it's just circular reasoning, I can't stand this shit. It just feels like gaslighting to me. But even if you go with what he's saying, even if you give him the benefit of the doubt, this is where, again, it falls back on those jury instructions. Because that languaging is so specific. And if the jury followed it to the letter, right? They used the same type of languaging. And we saw them do that. We saw them in their jury notes mimic or mirror languaging that the court would use or that the attorneys would use. Anyway, but you know what? I think that I really hope beyond polling the jury, which I hope they do, I hope that they ask them specifically why let's just say that in the case that they do talk to the jury. Let's say they talk to any number of them or all 12, whatever. And they say, yep, we were unanimous on counts 1 and 3. I hope to God that somebody asks them, why didn't you say something? Because that will settle this once and for all. Okay. And the thing is that that's the question that needs to be asked. And my thought is if they ask that question, the jurors are going to be like, what do you mean? They're going to be confused. That would be my gut instinct to it. They're going to be like, what do you mean? Why didn't we say something? Because it should, can you imagine? It's like, it's not our job. Like, you know what I mean? Like, it's like, we followed the rules. Like, I could see why, I don't know. It shouldn't be their job, but they're going to have to get to the point of where it's clear that the problem is the jury instructions, right? In order for this to not happen again in the future. In my opinion, like, I think that's where it really needs to be fixed. But anyway, so my point is like, what he is saying here, it just pisses me off. It's literally like saying, let's just ignore actually trying to get any type of truth and let's just pretend that everything, it's just icky.
To do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury who is
Coerce
that they're in an impasse. So simply put,
someone's gonna have to coerce me to not.
When it comes to each of
I don't even know.
respective points, the jury in this case, when one did not return a verdict, two, counsel had adequate and ample opportunity to object to the declaration of mistrial.
I object to you, Lally.
Mistrial was prepared out of clear manifest necessity, which the court, case-wise, repeatedly stated as the full typical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries.
Oh yeah, this is where the audio cuts out briefly. It's funny because I got this go after this trial ended.
Twisting the logic into sort of a pretzel in order to have the circumstances of this case fit into the precedent. There's a reason for that, because there's clear.
That was interesting. Hold on, let's back that up again.
There's quite a twisting the logic into sort of a pretzel in order to.
Did you guys hear that? There's some irony there, isn't it? He says, does some twisting of logic into a pretzel. Well, you don't say, Lally. Dude. I had to do one more go. It's really gross to me. It's just, I don't like it.
Have circumstances of this case fit into the precedent. There's a reason for that, because there's clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly.
Not know, though.
Well aware that the case.
You not know when the precedent goes back? Shouldn't you know if it's precedent? Because there is a difference between a century and a decade, Lally.
Which are following jury deliberations and having been convicted after trial.
You should know case law you're basing your argument on when it's wrong.
That case stands for the proposition that where those slips when contradictions
All right.
that they were deadlocked, that does not guilty finding on the verdict slip does not contravene or overrule of the verdict as it is applied in the report. I'm quoting from that case, and I think it's directly applicable to what's been provided to the court so far. It states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were controlled, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is the contravention to that case law, in the juvenile, in blue, in raw, in gray. In all of the cases over the decades, in the centuries dealing with this, Lallybird itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes from Commonwealth versus Carnes as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave. That stated on it.
Yeah. I'm going to quote Judge Bev, 3 or 4 copies. She literally said 3 or 4 copies for the 12. So this is actually bullshit. How do you even be like, yeah, They had copies of the jury instructions. Well, of course, first of all, they should have. They didn't, but they should have. That's like the first. I mean, I'm just so, it just makes me livid, right? Like, hey, Massachusetts, get your shit together. Like, first of all, fix your jury instructions. And second of all, maybe consider printing one for each juror. Maybe helpful.
9 or 10 different times exactly what the unanimous verdict was and how to come to that unanimous verdict and how to report that unanimous verdict. And there was no verdict that was returned stating anything in this case. And in particular, the 2 charges that the defendant has complaints of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was doing, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the board referred to them as an extraordinary jury. And I know the board had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury has submitted to, which the Commonwealth would submit were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they reached an impact as far as their deliberations were concerned. As it pertains to
All this is
charges.
just, I'm sorry, it's just
Final
pissing
note.
me off. It's just pissing me off. This is so, because everything he's saying, it's gross. Because again, he's completely ignoring the actual issues here and why the jury may have used the language they used.
They refer to the charges in the plurality, twice within that meeting, as it pertains to
And we know now
exactly what.
that they were referring to count 2, and he knows it. That's why this is gross. He knows it.
When it comes to what they were communicating and reporting to be at an impasse in regards to, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about, how those things are formulated in their minds.
Exactly what I was saying. I love that example that Marty gave earlier, at kind of towards the beginning of his argument about the Boston marathon bombing, because of the whole thing with the 11 years. That was such a great point about how this was 11 years later, and they're talking about bringing back the 2 jurors to ask them questions about something related to the death penalty or something like that. Capital case. They're 11 years later. Yeah, we're glad you're here. Yay. Yeah, Kit Smith says there's nothing special about this case. True. If this had been any other case and jurors came forward like this, what would you do? Great point. Great points, guys.
Intense pressure that they
Wally's
felt,
just Lallybird.
the affidavit from the one juror in regard to the counter that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being.
Hey,
With
Kit
respect,
Smith. I'm realizing that Kit Smith may not have seen our swoop yet. We have a swoop now. Hold on, let me do the swoop. I know it's not time to swoop, but I just realized I don't want to forget, and I just thought of it. So hold on, let's do it. Let's do that real quick. Here it is.
It's a house.
Oh no, watch it again.
It's a house.
The joy that I had figuring out how to animate the road trip crew and Lally. Best thing ever.
to that is exactly what the case law advises against and governs as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process.
I'm going to smash something, dude. I'm going to smash something. And look at his face. Hold on, let me pull the bird down. Look at his face. How annoying. I'm gonna smash something. It is not. There is, dude, this is like, seriously, right? What he's saying right now, he may as well be arguing that the earth is flat. It's like, how can you say the words coming out of your mouth and be serious and have a straight face about it? Because it doesn't make any logical sense. Ugh.
We excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel has to object.
I mean, I have to
suggest
say,
anything else.
regardless of what you think, I hope it's clear to everybody that Marty had much stronger, like the arguments were much stronger. Like, regardless of what you think about anything else, this is his arguments. Lally's arguments are so. This is just there is nothing. There's no substance here because it's just all it is flawed. I mean, really, like, and Marty made so many. I don't know. And so if you look at it that way, even just trying to be objective, which I know I can't be in terms of this right now, but like, you know, I think that if you just look at the arguments and the merit of the arguments, again, it's going to be weird if Judge Bev doesn't do the right thing based on the arguments, right? And the merit of the arguments, which is your job as the judge, right? Even if you don't agree, you have to go with it. It's sort of like almost like, that's how it works. It's based on what the lawyers argue. It's just going to be weird if she doesn't,
This is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for a Tui Rodriguez. And understanding that asking for a Tui Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process. And experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just.
I don't know why he's even arguing this. I don't know why he's even arguing this because the defense, while in their motions, the defense had maybe sort of hinted at the fact that they didn't want or maybe it wasn't even in their motions. It might have been the affidavits actually. They had kind of hinted the fact that they didn't really want a mistrial, and there was talk of the Tui Rodriguez instruction and all that, and that they didn't really want a mistrial. I think that I think they made the right choice by backing down on that because I don't think that was their best option because there's room to argue that, right? As we're seeing now. But that's why this is stupid because guess what? Marty didn't argue in the oral argument. He didn't argue this. He didn't say, oh, they never wanted a mistrial, blah, blah. He didn't go that route. And that's smart. He didn't need to. But yet, Lally's arguing it because he wasn't, dude, he clearly can't listen and tailor his argument based on what he's heard. Anyway.
Where they were in their deliberative process at that point reported to be at influence. Counsel, and these are Mr. Yannetti's own words, on both occasions.
Oh, you did see a swoop? Okay, sorry. No, you didn't see a swoop yet.
From it, or argued for Tui Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. The counsel is intimating there, making an argument about it.
Arguing with an argument that wasn't made.
Leading down. Now, as far, and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states. Tui Rodriguez instructions permits, quote, the inference.
I know, Candace. I know. It's awful.
Alternative to mistrial.
Put the bird back up.
Versus
Bird
is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decision when it came to anything that was even perceived.
That was just utter nonsense. Let's do that again. That was literal. That was just literal nonsense. That's all that was.
Argument against any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest, and I would direct the court to the verdict argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of a manifest necessity is a deadlock jury or a hung jury. And that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Yaneni during his arguments for the two Rodriguez recognized the same. The dangers of coercion when it comes to deadlock jury are amply stated throughout the case law as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Cooper decision from the United States Supreme Court and the Supreme Judicial Court of this Commonwealth. That there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those, how the jury
What does
sees
that
whether
mean,
or not
Kid
they
Smiths?
have
I don't even
whether they
know.
have partial votes.
Riz?
I would also submit
What is that?
Counsel's argument is a little disingenuous when it comes to indicating that.
Yeah, I agree, 100%.
those
Marty,
cases only
yes.
apply when we're talking about.
I know Lally's out of his league here. Kids been saying that Marty is a much more experienced and accomplished. Oh yeah, eloquent, captivating. Oh yeah, I loved listening to him. I mean, I wish I could have heard him better, but honestly, it was an honor and a pleasure to listen to his argument. It was passionate. It was artfully done. It was logical. It was clear. It was compelling, and it was again, it came from this perspective of like, you know, we're all on the same page and just optimism and hope. And it was so refreshing. And then you've got this.
Charges with lesser included, or charges that have a multiplicity.
Sorry about the papers. I think I can do that.
Findings that jury can make.
Bring
It
them all.
ignores the fact that there are those two very charges or indictments that the defendant is seeking to dismiss here. They're very simple. Not guilty, but guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe, as far as not allowing for the court to inquire into those types of scenarios. So, yes, the defendant's position is that the court should uphold or inquire only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know if there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive holdings of the jury while they're still deliberating. The notes and communications from the jury, again, on 3 separate occasions, were very deliberately, as far as the language that was used, declared themselves to be at an impasse on 2 separate occasions, the last of which included language to the effect that any further deliberation would be futile. That is the very definition of manifest necessity, and left this court with absolutely no alternative other than to declare mistrial. And it is clear from the language of the jury's communications support, and it's clear from the case law and the rules and the law itself, as far as what the court can do. The 2 areas that counsel is talking about and sort of asking for an extension of the creation of new law, again, sort of special or deferential treatment to this case or this offendant. The 2 areas in which
Oh, yeah.
can make
That's what the Riz
have to
thing is?
do with some
Okay.
sort of bias. If
I
there's an
gotcha.
issue raised
I
with regard
gotcha.
to, whether it's
Interesting.
racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance.
Oh my God, Lally. Mid-sentence. Dear mother of God. Y'all. Hold on. Let's watch that part again. What is he doing? What is happening? Hold on.
In an instance, the jury's deliberative processes, or in an instance.
He just lost his sentence. Incredible.
Sorry, one moment.
Well done, Lally. Look at her. She's just, dude. She's just like, doo-doo-doo-doo-doo-doo. She's just playing a song in her head.
And in an instance,
Might even have
in which there is
I
some
don't
sort of
know.
allegation or
Not
some
even.
sort of evidence of extraneous influence. The defendant's not raising either of those.
She's not listening.
Specifically within those cases, what the court states, which is obviously binding on your own, is that those hurdles for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed.
Marty just shook his head.
Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process or their votes is specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror, or the juror calls you, it still does not allow for counsel or the court to then have these conversations with these jurors that delves into their deliberative processes.
I cannot
or
with
their
him.
deliberations.
I cannot with him though. Stop making an argument that doesn't exist, Lally. No one's trying to do that. Where
Sort of condense,
I'm gonna goat myself into oblivion,
and it states
guys.
simply, one cannot assume from the mere report of death.
You don't hear from
that the
me.
final verdict lurking
I've gone
within
into
the
oblivion.
may be extracted. Such
No,
inquiry
I-
may succeed
it was
in
nice
extracting
knowing you
a partial
guys.
verdict, but we could not have confidence that that partial verdict was part of the thoughtful and thorough deliberation process. The risk of jurors' coercion are too high, and the liability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlock.
Not enough goat in all the world.
Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by rules, is prohibited by the law, is prohibited by the development of case law over decades and centuries as to what is permitted. Certainly,
Yeah, it doesn't even follow logic.
Commonwealth nor anyone who wants to try someone who has been acquitted by jury of their case or retry. That's not what happened. There was no verdict returned.
Got to be done sooner, right?
Counsel had more than an adequate opportunity to address the court in relation to the declaration of this. And the court did absolutely nothing in finding manifest necessity as the only alternative that could have been employed in that particular case. Polling the jury then, polling the jury now. It's simply not permitted by rules, it's not appropriate, and therefore the defense motion should be denied. Thank you.
Thank God, he's done.
Reply, please.
You did it. We made it, guys. We made it. All right, excellent. Now, all right, now we can go back to normal speed. Now we can breathe. Yay, excellent. He's done.
There were two cases that Mr. Lally relied on, and they both stand for very different propositions.
Hi, we have a new friend, Kat Randall. Where is this case? Are you not familiar with this case? Like, are you saying where? Let me, like, are you brand new to this case, or do you mean like where are we in the hearing? I will answer. I'll happily answer your questions. This is Massachusetts. But if you want to elaborate on what you mean by what you mean by where, but yeah, this is Massachusetts. This is the hearing from just a couple days ago. Goat Oblivion is right. Yes, indeed. I mean, right. Even when the sound was not, even when he was talking into the microphone, right? It just, you know. This is from 2 days ago, or yeah, 2 days ago, the 9th, August 9th. I was trying to cover it live as it was happening, and then we had the big tropical depression here on the East Coast, and it took out the power. So I lost power like 20 minutes into the hearing. So we're rewatching the whole thing. Thank you, Kitsmits. Kitsmits is also helping out. But yes, Lally is just hard to follow, period. Yes.
Is of law. Commonwealth versus a juvenile. It's actually juvenile versus Commonwealth at 392 Mass 52, 1984. It says the judge was under no duty to inquire as to the status of the jury's
If you're
deliberation.
wondering what that's about, he says Commonwealth versus juvenile, he says, and then he says it's actually juvenile versus Commonwealth, 1984. So it used to be that when it came to an appeal in a criminal trial, right? That let's just say, let's take Murdaugh, for example. Okay, let's take Murdaugh. So the jury trial, right, at the trial court level, it's South Carolina v. Murdaugh. Okay, it used to be back in the day that when you would appeal, if you're the criminal defendant, when you would appeal, you would then be in other words, you would almost, the parties would switch to where you'd be the plaintiff. So then the appeal would say, this is hypothetical, right? Because it's not like this, but it used to be. The appeal would have been Murdaugh v. South Carolina. That would be the appeal. That has since changed, though, which is why he's specifying that back then in 1984, that case actually was juvenile v. Commonwealth. right? But today we call it Commonwealth v. Juvenile following that new system. So today the parties all stay the same, regardless of where it is at. And it just is less confusing that way. Oh, Kat, yeah, if you're new to this case, yes, this is I do think also really what's going to come down to having to rework those jury instructions for the state of Massachusetts. But yes, this case has a lot of implications for a lot of things.
On each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, "We deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. 2 separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts."
Oh, wait, all of a sudden she's listening? Hold on, wait, well, let me back that up. Did she just turn off her music or her headphones or pull her earplugs out or whatever she's doing? Hold on. Let me see if I can.
Commonwealth versus Juvenile. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus Juvenile.
Yeah, so I know. So yeah, the judges don't like to have to be the ones, right? So the thing is that, you know, where it's paused. Marty, rightfully so, has laid the ground, has showed her that she doesn't have to set the precedent, right? It's smart. He's saying you can follow what they've already done. You don't have to do anything new here. Look at Murdaugh, right? So here's the thing. I do agree that there could be precedent here, but I don't think it's going to come from her. And I don't think it has to. Because in my mind, really what needs to happen, again, it comes down to those jury instructions, but that's not something that she has any control over. That's like a legislative thing. So in other words, that would be something, that would be a whole different process. I don't even know what the process would be. I don't know how they go about that, but you know, it's the model jury instruction. So there's like a committee, I would imagine, and the committee would rework that if that's what they choose to do. All she has to do at this moment, right? One step at a time, right? Baby steps. All she has to do at this moment is poll the jury. And that's not anything new. She doesn't have to be any groundbreaking pioneer. She can follow in Justice Toll's footsteps. She can follow in all these other footsteps, right? And all the other examples of cases where they poll the jury. And like Marty pointed out so rightfully and correctly, poll them just like you could have done then at the time. And again, I pointed this out. I think he said that in a way where you could replace could have with should have. Poll them now like you should have done then. But he did it so artfully. I loved it. Yeah, it's right. It's weird.
Was as if count 2 in this case was the only count, and they discouraged.
Right.
And it kind of
Exactly. And Kidsmiths, that's why, again, for me, that's why the jury instructions is the best argument for this. Because again, it takes the impetus or the responsibility off of her. That works. That works because A, you're gonna go a lot further with her if you don't blame her for shit. But B, again, it doesn't make her the person to have to set any precedent. So that's the whole thing. She read the model jury instructions as they are. She did. So the problem, those jury as we started this whole live stream out, the very first thing we did is we went back and watched that snippet from where we were watching it before, and to see like the exact languaging there in the jury instructions. So so it's not all on her. No, it's definitely not. And again, it's like there are so many things that could be on her, but you don't need to go there because it all comes, even if you go there, it still is going to come back to the jury instructions no matter what. So right. Yeah. Yep. They can, I don't know if Kat Randall, I don't know if you watched the Murdaugh evidentiary hearing, but that's all they have to do is they just, Marty even said, we will waive having the cameras and shit, right? But they could even follow Murdaugh where they had cameras and they just didn't show the jury, so.
If court questions as to where the jury stood on lesser includers. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lally referred. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser includers. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion our case.
Right.
We're not dealing with one count vertically with multiple charges. We're dealing horizontally with three separate charges. He's
distinguishing the case law again.
Both
why it's not on point. The prosecution's case law is not on point. Also, Nightbot's going to put the Discord link in the chat too for anyone who's new. 100%. No, 100%. That's exactly right. Lally did. I mean, literally, he beat them into submission, essentially, right? With his stupid Lally words. Speaking of which, squawk. Also, let me put the commands in the chat. Or, sorry, I'll have Nightbot do it. So, yeah, no, it was, yeah.
Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. And the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Bluford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they needed to decide all the different allegations within a single charge. And they came back and said, we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on.
Does everybody understand what he's saying? Or does anybody want me to explain that? I'm happy to explain that. I don't want to I guess I can just go ahead and explain it. But so there's a distinction between a case, like in the case law that the Commonwealth is using, where there was only one indictment and it had lesser included. So like with the juvenile case with the Bluford, there was only one indictment. I don't know what they were. Let's just say Grand Theft Auto. I don't know. I'm just making something up. Let's just say that, that was their only indictment, one count, but then there were lesser includeds to that. Okay. That's different than having three different indictments or three different charges, which is what is the case here. And then you have lesser includeds on one of those three. So, so he's making that distinction that if they were talking about polling the jury about count 2, then maybe you could see there was some sort of overlap, although they're still different because there's still 3 counts, right? But that's not even what they're talking about. They're talking about asking the jury about the other indictments, which there's not lesser included. So hopefully that makes sense.
Coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until
again, when I covered those documents, those most recent documents, I made a video. It wasn't a live stream, but it was just a video, whatever it was, like a couple days ago. Like I was saying there, like I had a lot of problems with Lally's. Okay. The Commonwealth, all right. The Commonwealth has already done it. That's why I can't stand it. I can't stand this because it's like, ugh. The Commonwealth already had juror dough. And see, I think everyone kind of forgot about that. But the Commonwealth has already shown that they can communicate with a juror and that they can actually have, in fact, a lengthy affidavit. That lengthy affidavit that they had from juror Joe. Very lengthy. They had all that. And that juror remained anonymous. And that was the Commonwealth. So I don't understand how you can. Do they think people have such short memories? I don't understand. But they've already shown that they can do it. So I mean, the other thing is, though, it was clear from Lally's tone, we're just not going to talk with you. I mean, you know? And the thing is like their ID was secure with the defense. Like, I think they gave up because they're like, yeah, clearly they don't want to hear it. You know what I mean? Like, that would be my thought. Like, these jurors are not stupid, okay? They know about juror doe. They've already talked to the defense, and their IDs were not leaked, right? Because we know it was probably the same jurors that reached out. So these jurors that reached out already know it's possible because it's already happened to them. They've already had their identities preserved and redacted or whatever. They have not had any issues. So then after they've already come out and had these affidavits and blah, blah, and then they go to the Commonwealth, and the Commonwealth's like, yeah, well, we can't. It's like, they got to know that's bullshit, right? But if I were me, what I would be hearing from the Commonwealth is they don't want to hear it. So there you go, you know? Yeah, but I don't know what difference it makes, though. I mean, I guess what you're saying is Judge Bev's office was able to call her juror doe, but the Commonwealth could have done that as well. I mean, the point is that the Commonwealth arguing that there's no way to keep them anonymous is just complete bullshit.
Reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached two decisions, two general verdicts, but we're in an impasse on a third one. The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Shoutout case, where they've had, just an overwhelming amount of media regarding.
And the other thing too,
Boston Marathon 2013.
Oh, back to the Boston Marathon. The other thing too is that even if it was Judge Bev, again, Judge Bev is the one who would be polling this jury, right? So really, that's what it comes down to. Judge Bev would be the one polling the jury if she chooses to do that, or if she chooses to poll everybody, or chooses to poll only the ones who reached out, whatever the case may be. She's going to be the one doing it, and as we know, she's already shown that she can give them a different name, right? So, but let me see what he's saying here. I'm going to back this up a second because he's going back to the Boston Marathon thing.
Might be exposed to media, and that's certainly more than true in the Shoutout case, where they've had, just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, and the government's investigation, the trials. Jurors knew what one jury.
Right, he's comparing the amount of exposure.
Yeah,
right?
First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you.
I love that he's using that as an example because it's local to them, right? The Boston Marathon. I think it's a great example because, again, this is so close to home, right? So I appreciate, dude. Thank you so much for the super chat. Thank you. You're welcome. Thank you, and you're welcome. I'm happy to cover it. Oh, right. Absolutely. Yeah. Right. That's exactly right. They're getting the message that the Commonwealth doesn't want to hear them. That was my takeaway for sure. Yeah, they won't be heard. Right. Yeah, because I think it's obvious, like their identity can be protected. Yeah. So, but yeah, I love that he's bringing the Boston. Yeah, again, that's just, it's talking, it's relevant in so many ways, right? Because again, he said after 11 years, they're talking about questioning jurors again after 11 years. And then it also has the whole thing of like how much media exposure. I mean, that had way more than this trial, right?
You to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Lally's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness?
No one's trying to say any of
Why
that.
did you vote a certain way? Or what
I
did the
agree,
other
Thunder.
11
I
jurors say? A
How's
deliberating
the move
jury is
going,
not
by the way,
focused.
Thunder?
It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we have a verdict.
Yep,
Which
yep.
is, did you unanimously determine
Yep.
as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was
Yeah.
there ever
Look at this.
deliberation?
Again, he's giving them every option. He's showing her, here's all the different ways Mr. Lally can ask these questions, or you can ask, or Santa Claus can ask, whoever, and he's saying, we can have it without the cameras, and there's all these, it's just the number of options here, I think, is so good. Because think about the difference in scope. If you compare this to the Commonwealth is saying there's only one option, don't do anything, right? Oh, Fender, I was asking how the move was going. So I haven't actually checked the Discord today. So if you've typed something in there to update us, then I apologize. But yes, I'm just curious how the move's going. So, right, of course, I know OJ, another great point, right? Isn't it so crazy that that case was like 9 months or something, wasn't it? No, as in you're not done moving, or no updates. Okay, gotcha. Because last I heard you were, or last I saw you were packing up, and you were saying you had stuff from like when you were 12 years old, I think is what you were saying. That was the other day. But yeah. So but think about this, right? So Lally's argument is like there's only one option. Ignore all this. That's it. And now look at this. The comparison here, right? Juxtapose that to what we hear from Marty, which is look at all of the options. I think that if you're a judge, that is compelling. I would think, right? Because again, options are a good thing, right? Options are a good thing. And it's the other thing that's crucial is that by giving her all of these options, she doesn't have to choose which option yet, right? Like, in other words, she could, I don't even know what her response is going to look like, I guess in order, but she could come back with something that is positive for the defense, saying something like, we're going to have another hearing to talk about how to go about polling them or whatever, but she doesn't have to actually decide which option. She just has to decide, okay, I have options. We're going to start there. You know what I mean? So, okay, cool. And you're going to a different city now, though, right? Because I know there was talk of the different jobs and stuff. I'm trying to remember which things were where, but it's also hard because I don't live in India.
After you reached that unanimous decision. In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted the mistrial, he could have asked for a mistrial. Then Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of deliberation. He asked for a Tui instruction. And it's inferred by a Tui or a Rodriguez instruction in the state court. Tui, I think it's a 19th century federal case, is that you have hope when you're asking for the Tui instruction. My experience, usually the prosecutor who's confident in the jury that wants the Tui. So, Kat Reno, do you have, I guess, a link to jump on the? I don't know what that
means to jump on the live stream talk. Do you mean to have somebody come on? I've never done that before. I don't even know how to do that. I know everyone else does that, but like I don't have, that would be new to me, to how to do that, if that's what you mean. Lisa Lee's asking, do jurors need to be, oh my God, is that a mosquito? No. I hope that's not a mosquito. Okay. Do jurors need to be physically sitting and watching from inside the courtroom, or can they be? Okay. Do you mean if they do like if they poll them? I think, is that what you mean, Lisa? They can. So there's a lot of ways to go about it, right? Like the first thing that Marty is saying, like of the options he's offering, is like she could just say, you know what, the affidavits that we have, which are from the attorneys, right? But she could just say, yeah, the affidavits that we have, that's enough. I believe them. I believe them when they say everybody was unanimous. We won't go with that, right? Or like he's saying, the medium option was like you could have those jurors affirm those statements. So there's ways that they could. There's ways that she could reach out to them, I guess, in a way. So yeah, I mean, she could reach out because it would be the same thing if they were to call them in, right? Like, in other words, they could do it, I think, through like affidavits and stuff, and just do it that way and not even have to bring them in. Or they could bring them in and physically they would have to be there, but they don't have to show them. Like, I don't know if you saw the Murdaugh evidentiary hearing, but the way they did that was they just had the cameras when the jurors were present. They had the cameras focusing on, other people, like the attorneys or the gallery or the judge, and you could hear the jurors, but you couldn't see them. But yeah, so they can remain anonymous even if they're there in the courtroom. Hopefully that answers your question. Okay. Oh, that's interesting, Fender. That's interesting. Huh. Wow. Thank you for that. I did not know. That's wild. Oh, I see what you're saying. Right. Yeah, I know, like Recovery Addict does that. That's, I think, maybe the only one I've seen who does that. That's so beyond I'm not opposed to that. I think that would be fun. That's so over my head though with technology. I'll be honest, I'm really low tech. I know like with Recovery Addict, for example, is just the person who I think of that does that. And he's so high tech, right? Like he's totally ahead of the game with all that, the way he's got the setup in every way. It's really impressive. But he's got it set up. I don't even know. He's got it set up. That's all I can say. I don't even know enough to say how it's set up. Oh, wow. That's wild. Wow. 14 days. That's insane. Right? I know. Yeah. Unfortunately, I don't have kids that can help me. I have Frodo, my dog. But yeah, I mean, it's because you have to have, I don't even know how you do it, but I know he's got like a robot number type thing, or it's like, I mean, what is it? Because it's like not his real phone. I don't even know, clearly. But if ever someone wants to try to teach me how to do that shit, feel free. Discord would be the way to do that. Yeah, I'm totally not opposed. And as far as like just keeping in touch and chatting and stuff, Discord's the way to do it. It's not through the live stream, but we can do all kinds of things through there. If you're not familiar with Discord, Kat Randall, I'll put that in the chat again. I highly recommend. I think it's the way of the future. You can chat, you can do video calls, messaging. It's the best. Anyone else who's in the chat will tell you how awesome it is, I would imagine. So, and it's free. So, all kinds of cool things are possible through there. So yeah.
Instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you had the defense lawyer asking for a Tui instruction, reflecting that he wanted further deliberations. So it's no answer, and the Ray case does not say that when you ask for a Tui instruction, you are really asking for something more than a Tui instruction. TUI means I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those two colloquies on the Friday before and then on July 1.
Hi, I'm guessing, welcome to the Discord. Glad you're here. Happy to have you. If you haven't used Discord before, let us know and we'll help you out. But we've got the different threads and stuff, as you know, other servers have if you've used Discord before. But like general conversation is usually in the Scroll Crew, but you can check it out. Let us know if you have any questions.
We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited under the federal rule of 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read an internet. We have evidence here that the jury acquitted Ms. Reed.
Yeah.
What can be more central to
That's
the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution.
So I think the only thing I will say is I wish he had made that sentence a little bit shorter. That's really the crux of it. And that's where it comes, we're going to hear it again. That's where it comes back to that thing of we don't want to put form over substance, right? Because the whole point of the justice system, right, is we do not want to convict. I mean, this is the whole point. Double jeopardy, presumption of innocence, all of this. And if a jury has acquitted you, right? And so I only wish though that maybe I'll point out where I think he could have stopped it and then started a new sentence for it to be just a little bit more impactful.
One of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read an internet. We have evidence here that the jury acquitted Ms. Reed.
Oh, hold on.
What can be more central to the core values?
So we have evidence here that the jury acquitted Ms. Reed. What could be more central to the core values? And then he could end it by saying of the court than that, or core values of the justice system than that. I would end it there because I think that is such a powerful statement. That's the crux of the issue, right? We have evidence that the jury acquitted Ms. Reed. What could be more central to the core values of our justice system than that? Bam, right? But unfortunately, I mean, again, I love him. I think he's phenomenal. This is just, it lost a little bit of impact for me because he starts to elaborate further.
Our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence.
What a great point.
A second 12.
What a distinction. Now she has to convince 24 jurors. Wow. Think about that, guys. I mean, that seems obvious, but like, it's actually not. Like, that is wild when you think about it. And what a great point.
Convince the first 12.
Wow. Wow. Well said.
All right, thank you very much. I'll take this under advisement.
She even offered Lally the opportunity to say more stuff, and he said no to say more stuff. That's all I got for him, right? And he said no, I don't want to say anything else. Interesting, right? That he didn't want to say anything else. Hold on, let me hear that again. That's surprising to me. Huh.
Thank you, Judge.
Thank you. Any responses to Lally or you all set? All right, thank you very much. I'll take this under advisement.
I mean, all I have to say is it's powerful. It's compelling. And again, even no matter what, like, let's just, if we're trying to even just look at it objectively, there's so many things he did right. Like, again, he took the responsibility off of her. You don't have to do anything new here. If this has already been done before, here's all the pathways. And then again, I love how he gave her so many options. Gave her all these different options. You can do it this way, this way, this way. And again, also this coming from this perspective of we're all on the same team. I mean, but I really think that one of the key things is going to be the options that he did in terms of what he did right here. Because when you compare that to the Commonwealth, just the one option, which is just nothing, right? Like, I think it looks way more appealing, right? So, so that's all I got for this hearing. Let's see if what else happens on this and Boston. What else they do here?
Judge, when I handed the Nicole case to you,
Sure, thank you.
Because the camera's staying for a bit. Let's see what happens. Oh, they're chatting. Huh.
Football rise.
It's funny that they didn't cut the feed immediately like they did during trial. She's getting right on out of there like she was. Look at, dude, I love him. I want him to adopt me as be my grandpa. So I'm going to take this opportunity to say shout out to Judge Peterson. For anyone who hasn't been watching the coverage that we've been doing of the Ezra McCandless trial, this trial is so great. It's fascinating. It's fascinating, and it's great lawyering on all sides. And I love this judge. And one thing that just thinking about it, because I've actually contrasted with Judge Bev because it's relevant. You know, like this is a judge who, like, similarly to like Judge A from Depp Heard, right, or Judge Newman, is endlessly patient and is there for as long as the attorneys need to talk about stuff, and everything's on the record. And one thing for anyone who hasn't seen it yet that is so awesome about this trial that I've never seen before in a criminal trial is, you know, just like how every trial has sidebars, right? When they go on the record, like it breaks and stuff to like discuss shit, they go over every single sidebar and they talk about what they talked about at sidebar. It's the best we're ever going to get in a criminal trial, guys, to sidebars, right? Like they'll be, you know, whatever it is, if it's lunch or morning housekeeping, whatever the case may be. And they're like, okay, or I guess if it's like, it couldn't be the beginning of the day, but like, because they wouldn't have had sidebars yet. But after they've had sidebars, then they go through each sidebar. And it's so funny. The judge and the attorneys, they go through it. And they say, yep, so we talked about this and this, and then this was objected to, and then this happened, and blah, blah, and then this, and they literally, I've never seen that before. And I think it's like they're making their own record because they don't, you don't have transcripts yet. I've just never seen I've never seen that. And like, it's really incredible, actually. It's like, whoa, because they're making sure that they all understand what happened when it's still fresh in their memory. I think it's really smart. But for me, from my perspective, as someone watching the trial, it's such a gift to have that because normally we don't know what happens at sidebar ever. So yeah, like again, why we don't hear the sidebar, but they almost do a replay of the sidebar, right? Is what I'm describing. They come back and they say, yep, here's what we did. So great question. Does Beth have a night job? I know. It's wild, isn't it? It's really, I agree. And so you compare, but anyway, I was going to say, like Judge Peterson in that trial, so they go through they go through everything they talk about at sidebars, then they go through whatever else it is they need to put on the record. And then Judge Peterson always says, okay, anything else? And there's always something, right, with attorneys. And they say, actually, Judge, yes. And then they go say, just this one thing, I'll be brief. And then they're never brief, right? And then they go on. And then and it's like, what this judge happily will stay there for an hour as they put everything. I mean, it's really, and listening, I don't know. It's great. It's great stuff. Candace, she slings donuts. Oh, dude. Glad you're here. You put an old scroll video. Okay, fun. I'll check it out. So awesome. We're happy to have you. Very good. So yeah, let us know if you have any questions about how to do anything on there. But yeah, and the other thing that's cool too is you'll get notifications too for live streams and videos and stuff through the Discord, as YouTube doesn't always, they don't always come through. Dude, I don't know. It is, I mean, I mean, I'm not the only one saying it. I remember like even EDB commenting on it and saying like that they've never seen a judge who literally doesn't even talk to the attorneys. They don't put anything on. They don't communicate. There's no communication at all. Like they have to beg her basically. Please, will you answer our question? And I remember I mentioned this too, like when they're doing the jury instructions, she cuts off the freaking one of her court clerks or court staff is like has a question and she's like so rude about it, man. It's wild. She's like, no, I'm not gonna answer your question. We'll figure it out tomorrow. It's just like wild. I mean, I just don't even know. But yeah, so the definitely for anyone who's curious and wants to see another good example of a good judge and good lawyering on both sides, the Ezra coverage. So yeah, so that's it for this hearing. I don't think there's been any other court filings. I'll double check just in case, but I don't think there's been anything like come out yet about this. Does anybody have any other questions about this or about anything, Ezra or Murdaugh, anything at all? General Scorlin, as I look, and yeah, I don't think there's been anything else here. Yeah. But just for fun, let's do this just for fun because it's been a while and I miss it. Let's do this just for fun. You guys want to see some gray boys? This is my what we're about to see here is like this is like my happy place. Wait, sorry, did I pull up the wrong thing? Hold on. Let me. Oh no, this is the right thing. Just kidding. Just kidding. All right. This day will live in infamy. This day that we found this. Good night, Candace. So you're very welcome. Yeah. So yeah, so I'll keep you guys apprised. There's the guineas. I'll keep you guys apprised of when anything else comes out in this. But yeah, definitely for anyone who hasn't checked out the Ezra, if for anyone who's new here, also we're glad to have you. And I do very specific timestamps, as you'll see. So if you're wanting to catch up on anything, I have playlists for every trial. And I'm a musician, so I have playlists for that too. But I have playlists for all the different law stuff that I'm covering and have covered, whatever. But for each video, I have really specific timestamps. So for anybody who's like on replay crew, rewatch crew, I try to make it easy because I know what it's like. And that way, and it also, honestly, makes my life easier too. If I need to find something specific, I can find it. But yeah, so if anyone's like, what's all this Ezra business? Because it kind of flew under the radar. Again, if you check that out, there's a playlist. And again, there's very specific timestamps as well for everything going on there. But yeah, there they are. And let me do our swoop one more time just for fun.
It's a house.
It feels like such a short live stream. I'm like so used to like, a minimum of 6 hours. That's kind of crazy. And the other thing too is that we will at some point do the other things we've talked about with Deputy Heard. I'm going to be working on putting together the Amber's full deposition thing. And also there's the Australia recording. So we will do that. I'm just like balls deep in this Ezra right now. And we're getting to like the crux of the matter, as they say, with it's a great trial. It's like, I think we're on like day 4 and the prosecution, dude, witnesses are in and out. I mean, direct exam is like 4 minutes for so many witnesses. It's wild. And that's without cutting anything. They're just like, if you want to see a good example of a trial, like not wasting any time, moving, good lawyering on both sides, great judge, and just really like being efficient, like it's incredible. They've already been through so many witnesses. It's kind of mind boggling. And and they're thorough, but they're like, we're not going to waste anybody's time. Anyway, so yeah. She didn't say. She said she'll take it under advisement. We have no idea. Could be could be tomorrow. Could be next week. Could be, I mean, it can't be after. I guess the in terms of the date that she gave us, actually, I've got a banner for that. Where is it? I still have this. So, all right. So I can say definitively that it cannot be after January 14th because that's the final trial conference, right? So it has to be before that. But I mean, other than that, it could be, she just said she'll take it under advisement. So we'll keep an eye out. I refresh that shit all the time, as I do with the Idaho cases. I was just thinking about this the other day. I wish every state, okay, this is the only time you're ever going to hear these words come out of my mouth. I wish every state was like Florida, but specifically in that Florida, everything is public for cases immediately. Like everything is public. Body cam, court docs. I mean, unless it's sealed to protect, in certain cases, but it's all public and it's all accessible. I just don't know why. I wish every state was like that. And it's crazy to me that of all places, Florida is the one, right? And I think Florida is the only state, I'm pretty sure, because they have that specific law. I'm pretty sure they're the only state. And then Idaho gets second place in my book because they have at least a really good, well-done website that keeps you up to date with the latest court filings and cases of interest. Sorry, Fender. I wish every state was like Florida. So right. Yes. But and it's so funny because as I was thinking about Florida, this was like this morning, and I was having that thought. I'm like, oh my God, I can't believe I'm having this thought. But like, it's specific to only that one thing. But it's so wild that it's Florida, of all places. I know, right? I agree. The one thing Florida gets right. Yes, that's it. That's right. That's exactly it. It's really funny, though. You would never think, right? You would think if it's going to be a state that's like, yeah, we're going to make everything transparent, everything, like literally open as it should be, right? You would think it would have been, I don't even know where, somewhere else, anywhere else. Like, I don't know, Vermont. I don't know. But Florida, they're like, yep, we're going to put, and I was thinking about how too, it's so funny because, there's like the Florida man and like just the craziest shit. I can't tell you how many times I see something, whether it's just a headline on like, YouTube for long crime or whatever, and it's like, you just see you see the picture or you see a headline, you're like, oh, you already know it's Florida. You just know it's Florida. It always is. So, I mean, it made me wonder if like, and then I thought to myself, well, I wonder if the reason there's so many cases coming out of Florida, maybe it's because of this law. Maybe if every state had that same policy, every state would be Florida. But then again, I was like, well, but also it could just be because Florida. Right. That's right. This is the conversation that I was having with myself. I prefer to have it with you guys. So maybe Florida is so transparent out of pure necessity, right? I think Florida has so many weird cases they had to make it good. That's exactly. And that's the other thing. It's like the chicken or the egg, right? So which thing came first? That's really the question. Let me see if I can find something about it. I think it's called the Sunshine something. Can we learn? Let's learn together. Let's learn together, guys, because learning is squirreling. All right, let's do this. You guys ready for some surprise learning, squirrel learning? Surprise, surprise. All right, let's learn. I guess this person's motto is stronger, safer Florida. It's not very compelling. Okay, the Sunshine Law. To assist the public and governmental agencies in understanding the requirements and exemptions, to Florida's open government laws, the blah, who cares? Okay. Florida began its tradition. Should I say this in a funny accent? Florida began its tradition of openness back in 1909. No, I don't know. I don't know how to say it. With the passage of Chapter 119 of the Florida Statutes for the Public Records Law. This law provides that any records made or received by any public agency in the course of its official business are available for inspection unless specifically exempted by the Florida legislature. Over the years, the definition of what constitutes public records has come to include not just traditional written documents such as papers, maps, and books, but also tapes, photographs, film, sound recordings, and records stored in computers, and also like body cam footage, right? Florida's government in the Sunshine Law. There it is. So this is going to give us insight. Government in the sunshine. That's why they wanted to be transparent. Incredible, of all places, right? Enacted in 1967. Wow. Today, the Sunshine Law regarding open government can be found here. These statutes establish a basic right of access to most meetings of boards, commissions, and other governing bodies of state and local governmental agencies or authorities. Throughout the history of Florida's open government, again, I'm eating my words. You're going to hear me say it twice, guys, about Florida doing something right, because I feel like I need to say it again, because this is like so great. Like, look at this, open government. So it's like, that's the whole point. Well done, Florida. Every other state should follow suit, in my opinion. North Carolina, come on now. Florida can do it, then anyone can do it. Throughout the history of Florida's open government, its courts have consistently supported the public's right of access to governmental meetings and records. Y'all, this is like moving to me. Like, I could get emotional, honestly, about this. This is incredible. As such, they also have been defining and redefining what a public record is. Wow. And who is covered under the open meetings law. One area of public concern was whether or not the legislature was covered under the open meetings requirements. To address that concern, a constitutional amendment was passed overwhelmingly by the voters in 1990, providing for open meetings in the legislative branch of government. Y'all. The Attorney General's office has consistently sought to safeguard Florida's pioneering government in the Sunshine Laws. Yeah, pioneering. Our attorneys have worked both in the courtroom and out to halt public records violations. In 1991, a decision by the Florida Supreme Court raised questions which made it clear that the best way to ensure the public's right to access all three branches of government was to secure that right through the Florida Constitution. The Attorney General's office then drafted a definitive constitutional amendment, which guaranteed continued openness. I'm going to highlight this. In the state's government, and reaffirmed the application of open government to the legislative branch and expanded it to the judiciary. This amendment passed in 1992. Wow. Shout out to Florida. I mean, this is how it should be done, in my opinion. Just one squirrel's opinion. So expanded it to the judiciary. I wonder if that means that some of the stuff that we're used to talking about, that happened in 1982, but still, that is like forward thinking, isn't it though? Amazing that the government in the Sunshine Law was enacted in 1967. Incredible. Florida. Well done, Florida. Well done. I just wish other states would follow suit and do that. So yeah, so we all can learn. Wow, they even have a phone number on here. You can call them. Amazing, right? Dude, the amount of trouble I had getting in touch with when I lost my internet before I saw, actually, no, I guess I saw that the tree was down and then I went, anyway, the amount of trouble I had trying to talk to a person is insane. I'm sure you guys can imagine. It's like, just doesn't make any sense. So yeah, so anyway, y'all, I'm going to get working on finishing up my next Ezra video. We'll do that tomorrow. And I'm really excited because shit's getting really interesting. And there's a lot of overlap with Murdaugh, even just starting with the fact that there's a lot of mysteries of like, you've got somebody who's like staged a crime scene, right? So you're trying to figure out what's staged and what's not staged. Like what's evidence that of what really happened and what was fabricated or staged. And you've got like a person who's trying to maintain their innocence in a way and then like lied about everything. And then there's a lot of mystery of like, we still don't, you know, the person, in other words, didn't really tell us what happened. We have to figure it out type thing. So there's a puzzle. There's a puzzle there. There's a good mystery and good puzzle. And but then specifically when it comes to this thing with the victim's cell phone, there's some crazy overlap with that specific moment with Alex sitting on the railroad tracks. That's interesting that we're going to talk about. But yeah, so that will be tomorrow. And yeah, I will, as I said, I'll keep you guys updated with this and with anything else on the other cases that we're doing. Oh, I know what I was going to look up. One last thing. The Robert Tellis. Hold on, let me see if that's still starting tomorrow. Looks like it's still set for tomorrow. And is anybody interested in, like, do y'all know what that is? So I will say I really wanted to cover this when he was going pro se, and he's not pro se anymore, unfortunately. I mean, it's good for him, but bad for me, I guess, in a way. However, I might still try to do something with it depending on what happens. I think tomorrow is jury selection. Is anyone familiar with that trial? Tellis out of Las Vegas. Y'all let me know. But I will say, as far as my relation to this, I actually learned about this when it first happened, when he was first charged, which I don't even remember when that was. Let's see if I could find out. So somewhere around, let's see, it looks like 2022. Yeah, okay, he was arrested on September 8th, 2022. So it was right. Okay. Court TV obtained a copy of the transcript from the grand jury hearing. Wow. How did they do that? 6 weeks after his arrest, he was indicted on account of murder. So that's, I'm sure, where I first heard of it. I must have seen something from Court TV. But this would have been when it first happened. So this was like, what did I say? September 2022. So I started learning about this case then, and it's wild. And like, this dude is a piece of work, man. And so I've been like, this is one that I've been like waiting for it to go to trial. And especially because he was pro se for a bit, and then I guess he got an attorney recently, but he was going to be representing himself. So anyway, but yeah. Oh, not in the slightest? Is that not in the slightest as in you've not heard of it? So basically, this dude, Robert Tellis, in actually he's got like a campaign video thing. Hold on, let me see if I can pull this up. We can watch something about it. Hold on. Let's see if I can do that. Because he was like a he was in politics or whatever. This dude whose trial starts tomorrow. Let me see if I can find. Okay, let's see here. There's a local news channel. Let's see if I can find campaign video. Okay, so he was a public administrator for Clark County. Here, let me click on this and see what this is. No, we don't want to hear from you, Trisha. Clark County public administrator. Okay, hold on. But what it was he had like a toxic work environment where he was like doing all kinds of terrible shit with the women there, and like just like bullying them and threatening them. There might have been some sort of sexual harassment. I don't actually remember. But it was really bad. And so there was this investigative reporter named Jeff Gehrman, I think is how you say his last name. It's spelled like German, but I think it's pronounced Gehrman. And this investigative like reporter dude was exposing him. And there was a lot of corruption. Oh, you're fine, Kidsmiths. And so he murdered him, dude. It's wild. And he's definitely going to take the stand. That's already been like confirmed. So he murdered this journalist, dude. And like, that was it. And he stabbed him. But the weirdest part is the disguise he wore was wild. He tried to dress up like, I think his goal was to try to go for like a woman, like an old woman or something. He had the weirdest disguise, like costumey thing. It was really wild. And so he was caught on cameras, like Ring doorbell and security. They've got everything on camera of him coming and going from like the journalist's house, and it's wild. But anyway, the thing is that, you know, I don't know if I'll be covering it or not. I might just watch it. I might just cover it like when he takes the stand. It's like that's going to be the good part, right? But like I'm working so hard with Ezra right now, so but it's going to be interesting. So and he's definitely a narcissist. I mean, this dude, him on the stand is going to be worth watching for sure. So that will be something to keep an eye out for. And I'm sure I'll probably stream that. But let's look at this real quick because this says this is a local network. Let me do this real quick. This is going to say about him testifying. So let me add this to the thing. This is from a local TV station.
Well, former Clark County Public Administrator Robert Tellis is now expected to take the stand in his own murder trial. And thank you for joining us live at 5 tonight. I'm Trisha Keene.
And I'm Abel Garcia. It's been almost 2 years since Las Vegas Review-Journal reporter Jeff Gehrman was brutally stabbed and killed outside his home.
So there's the
J1 Jung has been covering the many twists and turns of this case.
That's right. And tonight she shows us the moments that led up to Tellis's trial set to start on Monday.
So this is a good little preview.
The murder trial of former Clark County Public Administrator Robert Tellis is set to kick off on Monday.
Tomorrow.
Many telling me it's been a long time coming.
There he is.
Our lives.
Alicia Goodwin and Jessica Coleman attend every hearing honoring Las Vegas Review-Journal reporter Jeff Gehrman.
So this dude was like a legend, man. This reporter was doing like God's work, if you will, in terms of exposing corruption, and he was really beloved by a lot of people.
Women worked with Robert Tellis when he was Clark County Public Administrator.
We're here to honor Jeff.
There
With
he is.
Tellis's murder trial now.
Oh, dude, yeah, the disguise. They might show it. If they don't show it, I'll pull up something else. You can watch it. We'll watch it if they don't show it on this.
Set to begin Monday with jury selection.
There he is.
Goodwin and Coleman tell me they're ready to put this chapter behind them.
We're ready for a verdict.
State versus Tellis.
On Wednesday, as I've done for the
I
past
remember
year and a
that.
half,
Oh my God, I remember that judge. That's right. I've actually watched. Okay, I was like, oh my God, I remember that judge. I watched his hearings when he first got arrested and he was pro se. I watched those hearings. Now I remember. Yeah, because he was pro se, and she was like trying to talk him out of it, you know, as they do.
Attended Tellis's hearing, this one likely the last one before trial gets underway. Attorneys for the Review Journal giving the court one final update on the search of Gearman's devices, the content becoming a battleground for the First Amendment as Gearman's employer moved to protect his sources.
So that's right. This has been a challenge because, man. So being a good journalist as he was, this whole thing about protecting his sources, right? So then there's this issue with oh, kids. I'll have to take. I didn't even notice. I'll have to take a look. The shapewear. So you mean like Spanx, that type of thing? But yeah. So oh, what was I saying? The right, the First Amendment. That's interesting, right? When you think about this is a whole issue with getting this technology and stuff.
Produced by August 12th, beginning of the trial date.
Judge Michelle Levitt questioning how the late production of evidence to both sides might impact the trial timeline.
How's that going to affect? I mean,
I liked the judge.
Tellis's defense attorney Robert Draskovich telling the judge he wants to keep the Monday trial date.
I mean, depending upon what's exactly going to be turned over at this time.
After the hearing, I asked Draskovich about obtaining data from Gearman's devices just hours before trial.
It's of great concern. You know, obviously our concern from the get-go since my involvement has been that there may be exculpatory evidence contained within
there he is. That's it.
Devices.
Kits Mitts. There it is. Here, let's watch it again. There, and for anyone else who's watching, not just Kits Mitts, but I know we were just talking about the disguise. There's disguise. That's it. I had a feeling they would play it.
There may be exculpatory evidence contained within Mr. Gearman's devices.
But he says his client is adamant about moving forward.
It's so goofy, and there's more. That's just a snippet.
Despite the fact he waived
Look at him making that face.
His right to a speedy trial back in October of 2022.
He has informed the court on multiple occasions, regardless of whether or not the Review Journal finished their review of the device.
So I guess the judge was successful because initially he was like, nah, I'm not going to get an attorney. But she kept trying to, you know, do what they all say. I mean, it's smart for him, but I'm like, God damn it. It was going to be so, dude. I mean, there's a lot of memorable pro se, as we know, and we haven't even gotten to Sarah Boone yet, but this would have taken the cake probably, honestly, if it works, if it still were the case.
He wanted to move forward.
I know.
With trial.
What is your strategy going into trial?
I know, right? It's like the least conspicuous. Isn't it hilarious? It's like a cartoon. And if I recall, he had some really distinctive vehicle which he drove there, and you see that person getting into the car.
You know, obviously, our strategy in this case is going to depend upon what the evidence is.
If I remember, it was bright orange.
My client, Mr. Tellis, has vehemently maintained his innocence.
Goodwin and Coleman tell me Jeff Gearman was the one person who listened to their concerns about Tellis and was willing to tell their story. Now they want justice.
When you're a confidential source, but then the only person that listened to you and was willing to be public is gone, it's like the passing of a baton.
Channel 13 has learned the state plans to call about 20 witnesses.
So let's take a look at that again. And I know somewhere there's videos of him doing his like campaigning, and you get to really see his personality, the murderer, I mean, and it's
exculpatory evidence contained within Mr. Gearman's devices.
But he said
the orange, dude. And it's Las Vegas, like in the summer.
His client is adamant.
It's so good. It's so good. Let's see if I can find one with like his campaign video. There's like because I know it exists. Oh, right. Hiding in the victim's bushes. Oh my God. Let's see what this is. This is happening.
Work backwards. As police investigators were serving that search warrant at the Tellis home, this county building that houses his office and the public guardian's office was temporarily shut down. You can see the signs from Clark County right here. They even are directing mail and delivery services to bring things to the coroner's office next door. 13 Investigates learned that Tellis came to work yesterday for only about 2 hours.
Oh my God. It's like this is right after it happened. happened? Holy shit.
Day, he was a no-show.
Oh my God.
Rewind to Monday when neighbors say they saw some strange activity at Tellis's home.
We moved here 7 years ago, and he was here before us, so it did seem a little bit suspicious. So.
Dave's
what I love about this. This is from a local news network at the time. Like, this is right when it happened. And talking to the neighbors. I love it.
Danella lives 2 houses away.
My daughter brought it to my attention and said that he's putting up a camera, and we just spoke about it, briefly, saying that, well, he's been there a long time. I don't know why he'd be putting up cameras right now.
Back in May, Jeff Gehrman published his first article on the Clark County Public Administrator's Office, writing that it has been mired in turmoil and internal dissension over the past 2 years, with allegations of emotional stress, bullying, and favoritism, leading to secret videotaping of the boss and a coworker outside the office. Gehrman reported allegations of a hostile work environment fueled by the elected administrator of the office, Robert Tellis, carrying on an inappropriate relationship with a staffer that has harmed the office's ability to deal with the public in overseeing the estates of those who have died. Gehrman further wrote, because of the brewing animosity, the top supervisor under Tellis, Rita Reed, decided to run against him in this year's Democratic primary.
Wow.
As the election date neared, Tellis posted this campaign video on YouTube that he
here we
titled,
go.
"The Tragic Scene I Found."
Okay, a campaign. This is what I wanted to see was the campaign video.
A few years ago, when I started my first term, I found a disturbing situation at the office. Unfortunately, I found that there were cases that weren't being closed and hadn't been closed for years. I also found that checks to families were waiting to go out so long that the checks went.
I'm pausing this to say a couple. This is what I was looking for. I'm going to back it up. This is what I was looking for specifically. I'm so glad we found it. So this is the defendant whose trial starts tomorrow. I believe it's jury selection. This is the defendant. Okay, this is his campaign video. And this is just, again, the murder only took place in 2022, so this is fairly recently. And but he was going pro se. He's got an attorney now, but he's going to take the stand from everything we know. So we're going to watch his campaign video before he was arrested.
Tragic Scene I Found.
A few years ago, when I started my first term, I found a disturbing situation at the office. Unfortunately, I found that there were cases that weren't being closed and hadn't been closed for years. I also found that checks to families were waiting to go out so long that the checks went stale before the families could get them. Tragically, there were even situations where the family members died before they could receive their own checks. But I'm very happy to say that we've turned that all around under my leadership.
Video came out in the wake of the county decision, as Gehrman reported, to hire former Clark County Coroner Mike Murphy to tackle friction in the public administrator's office after multiple claims of bullying and favoritism.
I'd like to ask you for your help now. I'd like to ask you to please be sure to vote for me in this year's election.
In June, as it was becoming clear that Tellis would lose the primary election, he began to push back online against worker abuse allegations, and he attacked the Review Journal's investigative reporting. In a blog that reads more like a rant, he accuses Gehrman and his opponent of turning Democratic voters against him. He wrote, "The article was intentionally gut-wrenching. It was so ugly that you almost had to believe it was true. I can understand why you might have with the writer's skill at pushing buttons. Also, the timing of the article was very convenient for my opponent." He added, "They are seeking to destroy me, both personally and professionally."
It's scary to think about.
Another of Tellis's neighbors, Devin Bonadeo, has been following the story.
With the media and politics getting so closely intertwined, I think it's just been, it's been a gross interaction with those two, and that just goes to show what it's looking like and the road it's going down.
Road continues on Twitter on June 18th when Tellis accuses Gehrman of going through his family's trash. He calls Gehrman a bully who slings BS. He tweets, "Looking forward to lying smear piece number 4 by Jeff Gehrman. I think he's mad that I haven't crawled into a hole and died."
So anyway, I just wanted to find that campaign video, which we saw. So, but that's just a snippet of what this dude, what's going on with this. But anyway, yeah. So that starts tomorrow, jury selection, I believe. And then, like I said, I'm sure I'll cover it when he takes a stand because it's going to be fascinating. It's going to be something else, as you can probably tell. So But more importantly, we'll have another Ezra episode tomorrow. But yeah, so that is for anyone who wasn't privy. I'll go ahead and type up the name so you guys can see how to spell it in case you want to look for more information about it. I don't know if anybody's even covering it. Actually, I haven't heard anybody talking about it in terms of LawTube, so I don't even know if anyone's covering it. I already knew about it from before, but that's the name if anyone wants to look it up. But yes, y'all are the best. Thanks for being here. Oh, I forgot to look at the shapewear kits, Mitz. Hold on, let me before I go, because this is important. Let me go back to the video that we were watching and look for that shapewear.
He anticipates on telling his story.
And our Jaewon Jung has been covering.
Okay, Kitsmits. Okay, I see what you're saying. Yes, we love the curvy. Curvy's great. That's so sure shaper. Okay. That's interesting. I wouldn't have even known that she was wearing. I don't know how you know that someone's wearing shapewear. How do you, is it like, I don't even know. Like, what is there I mean, she does look great, but I wouldn't have known. I don't know how you know. How do you know? But I like the sleeves on her dress. This dude. There he is. So yeah, so that was the last thing I needed to do. Go back to Murdaugh. Anyway, this has been a crazy one. Oh, okay. Is it like the fabric? Is that what you mean? Like the cut or the fabric or whatever it is? I could see the fabric. Well, I guess both really, right? Oh, okay. Interesting. Wow. Is it uncomfortable? The shapewear? Is it something that you wear every day? I have so many questions. You know, I'm nothing if not curious, inquisitive. Oh yeah, the Olympics are going on, aren't they? I was just seeing the thing at the bottom here. You know, Peacock, they have, you know, those things they always do, like the free trial on the different platforms and whatnot. And, you know, then they remember you for somehow. Anyway, the last time there was Olympics, so Summer Olympics, so 4 years ago, I guess it was, I used up my free Peacock thing then. And so I could watch like the gymnastics and stuff. And anyway, now I can't watch it. Oh, I see what you're saying. Okay. Right. So, but what I'm wondering is this something that you wear every day, like the shapewear stuff? And is it hot or uncomfortable? Okay. I see. Okay. I see. I mean, it's bad enough that as the women, you know, we have to wear like bras every day. I mean, I guess you don't have to, but like, you know, you do. But yeah, I see what you're saying when you now that I kind of know what to look for there, Kitsmits. You can tell that the stress is clingy, you know, if you will. That's a good guess. Interesting. I feel like there's a time. Okay, hold on. I feel like there's a time when Emily has had sponsors by somebody who does shapewear, maybe on the podcast. And I feel like I think I've heard it like maybe once. So I don't know what it's called, but I remember her talking about it. But, you know, you never know if it means she's actually wearing it or it's just like, you know, they have to say that. But she was talking, whatever the thing was, she was saying was comfortable, I think. I'm just remembering it now. Oh, I'm not even noticing the typos. It's all good. Are you on a phone, Kitsmits? Right. Oh, iPad. Oh, interesting. Okay, yeah. Do you use the Apple Pencil ever? Interesting. That's something I would have never thought of. I'm so like the smoothness would never have even crossed my mind. Thank you for enlightening me to that. That's something I just would never have. I would never have thought about that. The smoothness factor. Okay, yeah. Isn't it? Do you mark up sheet music with it on your iPad? I love it for that. Like when a student sends me like a picture of their sheet music or whatever, you know, you can mark it up. I don't have a Bluetooth keyboard, but I haven't really needed one for it. But yeah, I just use that. I love that pencil. Yeah. Cool. Yeah. It really I mean, I'm sure there's plenty of other reasons to use the Apple Pencil for other people, but like I like for music, like it's a no-brainer. Yeah, you draw. Oh, cool. Interesting. Yeah, I mean, you guys know how my drawing skills are, so I'm not, you know, I'm a one-trick wonder or whatever, one-hit wonder, one-trick pony. Yeah, that's a one-hit wonder with my squirrel. But sheet music. But you know, like I was saying on a somewhat recent live stream, what I've learned that was so interesting and surprising is I've learned that I love making thumbnails. Let's just for fun pull up. Let me pull up my most recent Ezra one because we added some stuff to it. And like it, what is I'm saying I'm a one-trick pony when it comes to drawing. Let me see where it is. Hang on, let me share that. Hold on. Like I love making thumbnails. I've learned, and that's like for me, like because I can't draw, but it was so surprising because I never really, because I can't draw. I guess I thought I didn't have like any creative things going on like with visual stuff. Like I don't know how to explain it. Like, because usually if you have like, and I'm not saying I have any skills. It's just I guess I would have thought that making thumbnails would have been a chore. You know, considering I have no technology and no drawing skills and no visual art skills and no graphic arts. I mean, you know, anyway, no skills related to anything of this, right? But what I found is that I really love making thumbnails, and it just dawned on me like, I don't know, a week ago or something. And I was surprised. I was like, wow, you know, it was like a thing that I was learning. Here I am learning something new about myself. Like, wow, like I really enjoyed this. Like I enjoy putting, it kind of surprised me that my brain enjoyed it is what I'm trying to say. Thank you, Kit Smith, saying things better than me. You didn't think you had that's exactly it. Any inclination for visual arts. Exactly. Yes. Okay. Yeah. You remember me saying it. Yeah. So that's, by the way, so we have the frog now added. He's in the jury. There's a couple other additions. We got the goat painting. We got the antler, which the prosecutor called a deer claw recently, and I died laughing. Deer claw. And I was like, from now on, it's a deer claw. But yeah, so yeah, I didn't think I had any inclination for the visual arts at all. And I mean, you know, I don't know that I have any skill, but it's just funny that I enjoy it. You know what I mean? Like, it gives me a Zen feeling, which is weird. I never feel Zen unless I'm running, but doing the thumbnails gives me that type of feeling. Oh, right. Yeah. Yeah, I will say the only thing that's prior to this that I would say, not that this even counts, I would say that like I've always felt like I have a good eye for like, I have a good eye for certain things. Like people have told me that I have a good eye for certain things. Like, but I wouldn't say they were visual arts related. Okay, I see what you're saying. Yeah, I guess I'm better with maybe the overall idea. Like I could imagine something, I just couldn't draw it. I guess that's why making thumbnails works out, you know? But speaking of Ezra, I'm going to get back to finishing up on the next video so we can have that for tomorrow. And okay, interesting. Okay. Right. All right. Yeah, that makes sense. I see what you're saying. See, I'm like the opposite, right? Like I've been told, right? Like I have a better eye for things conceptually, but you know, obviously can't draw. Amazing when people have both things, right? So yeah. So anyway, I hope to see you guys tomorrow for the next Ezra episode, and we will keep on top of everything else. And thanks y'all for watching, for being here, for being a squirrel, for being awesome. And I will roll the outro.